If the office objections are complied to be listed. Yes.
My lord.
Listed, yes.
My lord, old matter, my lord. 2023 until 2024 until June, they had given an OTS of 50 lakhs. I had paid 37 lakhs, but the remaining of 14 lakhs 75,000 is supposed to be paid. But I was unwell and I underwent a brain surgery. I was in coma. I have recovered now and I insisted of getting it settlement. But they are asking for 40 lakhs. Otherwise, they will take
We can't decide it this side of the vacation. Yes.
My lord, insurance company, my lord, they ordered pay and recovery.
This side. Yes.
Insurance policy, fresh matter, my lord. Pay and recovery has been ordered for the case which where we have not even given the insurance copy. They have moved for execution petition, my lord. Liability matter, pay and recovery. Kindly take it early, my lord.
How many?
Two cases, my lord. One more is also challenging liability on the misrepresented claim, my lord. Only two cases.
Did you file all that?
My lord, this was filed in the month of 9th, my lord.
From that time, it is never listed.
There was office objection. It has been complied 10 days early, my lord.
Clarification. Yesterday for the Christmas vacation, I got the dates wrong. It was inadvertently I got the dates wrong. As soon as I realized, I rushed to the school and I got the dates re-clarified, my lord. That dates correction has to be done. It was a genuine mistake, my lord. I couldn't recollect the exact. I didn't have the school calendar also. So I produced.
Then why did you tell?
Sorry.
Why did you tell all that without the clarity? No. Whenever the matter comes, you take for your arguments full time. Then order should be passed. Again, on the next day, you will come with a clarification.
Extremely sorry, my lord.
No, it's not about sorry. Why? How many times the court will hear? The court has no other work.
It's not about hearing, only the dates.
Hearing means it has to be listed. Again, the order has to be corrected. Is tomorrow? Yes.
My lord, fresh matter, my lord, surface notice has been issued, my lord. Today is the 7th day, the last day.
When did you file the matter? All fresh matters, office objections are complete, they will come.
Yesterday.
My lord, one submission.
I will not take up any matter. I have a bill. Tomorrow, if all the memos is verified with the court officer, why it is not come? If it is given yesterday, that is fine from us.
My lord. My lord, one submission.
I think I'll call the list. If
My
anybody,
lordship.
if one after the other, if you're mentioning, I'll hear. If this is a manner you want to mention, I'll call the list. Yes, what is that? When did you file? Please tell the court when did you file the expedition? When? What is the number? All the fresh matters, give it to the court officer. If their office objections are complete, they will come. So don't make a mention first. I will not take up any matter as well.
My lord, if I'm please permitted to make a submission,
my lord, one submission. My lord, one submission. There's a final hearing on CRPC 125 case in the family court. Last week, I had requested for a additional time, mentioning that we have a case which was filed as a petition here.
Why it is not come up in the list?
My lord, it has been filed on the first week of December. So we are yet to, in fact, last week also I made a mention here.
I'm asking why it is not listed. All fresh matters, they are listed. If it is not listed, office objections are not complied with.
My lord, we are clear.
If they are not complied with it, they will not be listed. That is standard instruction to the.
My lord, my only submission is the hearing is on Friday again, the final hearing.
If you comply with the office objections, it will come.
We have cleared most of the office
Not
objections.
most, all.
I'll ensure that it is cleared today.
If it is, it will come. We don't have to move at all.
If it can be heard tomorrow, because the Friday is the final hearing.
Tomorrow it is not possible for me, yes?
My
Lordships, kind leave, my lords. This is a fresh matter, my lords. We've complied with office objections on the 15th of November.
We can't list those matters at the fag end of the vacation.
DRT order is.
Please understand. Please
My lord,
understand.
office-
We can't,
1,275 days delay. That
We
they
can't- we
supposed to
can't.
go to DRT.
it is pending from the last 1 year. It can wait till January. Yes, next.
My lord, I am for the petitioner. The respondent has taken an ex parte order without serving a copy on me and by forging my mother's signature in the summons. And now my parents are paralyzed and they have taken the ex parte
What
order.
is that?
25 itself, it has filed yesterday itself, my lord. There is an extreme emergency and they filed execution and police are making me to run from pillar to post. Warrants has been issued.
Office objections complied with, list the matter. Yes.
Tomorrow, my lord.
May please, my lord, I'm seeking to file memos of posting for 2 writ petitions arising from matrimonial proceedings. It's filed on the 6th of December. The reason why I'm mentioning it is after we have filed it, we have received notice of contempt petition filed by them alleging disobedience of these 2 orders. The matter was listed yesterday and it's posted on Thursday for hearing of charges. The honorable court has indicated since we've not gotten a stay here, the case
What
will
were you
proceed.
doing from then?
My lord,
December 9th, from the day you filed this matter.
My lord, the files were not scrutinized. My lord, we will comply with all, in one of the petitions, we have already complied with all the office
All
objections.
because you don't have to mention the moment you comply with the office objection. It's a general direction that all should be listed.
Please, my lord, but if a date can kindly be given, we will comply with the office objections. I'm only mentioning,
Comply with the office objections, it will come.
please, my lord, but if a date could kindly be given tomorrow, the reason why I'm mentioning it is the matter is listed on Thursday, the contempt for framing of charges, my lord.
Whenever you feel that's not the urgency.
Please, my lord, but my writ petitions
I
will
can
be
understand if
rendered
this court, if
infructuous.
this
my
court is restricting the listing, or if this court is saying that the matters beyond this number, it can't be listed. I told them, all the matters, all preliminary hearing, wherever the office objections are cleared, list every matter to, if it is like that list may run into 100 also, not an issue. But without that, all of you come to the court and mention, what is the purpose?
The only reason I'm mentioning it is because the
You do
contempt
it,
is
you
day
do it,
after
it will
tomorrow, my
come.
lord.
Yes, you do it, it will come. Yes.
My lord, I am here the petitioner. Respondent trying to take position under Service Act. Kindly, we pay the 20% amount of the amount to my lord.
This
Kindly,
20% order, this court is not passing.
kindly tomorrow.
Fresh matter, it will come. Yes.
Lordships, kind leave, my lords.
The registry, wherever the office objections are complied with, all matters should come. Yes.
Lordships, kind.
What is that?
It is a fake regulations. In spite of producing document also, they have order for without pay and recovery, Lordship. And also again,
When was the judgment passed?
in the 2 days delay is there. Lordship. That is why I am requesting. Otherwise, I don't want. There's a delay in 2 days. I am not. Friday I filed
All the
because of,
insurance companies are now they
No,
are
no,
taking
Lordship.
up before the vacation.
because scrutinizing fake document. has been
Look at it, if office objections are complied, then only list.
Yes, Your Lordship, already complained, Your Lordship.
So this is a ECA matter. Entire amount has been deposited. Matter was filed on 12th September, my lord. Several memos have been moved. All objections are cleared, my lord. Now execution they are proceeding with. Entire amount is also deposited before the court.
Now, why I am not able to understand these submissions? Say, office say they are posting. They say they have complied with office objection, they are not listing. Where is the problem? That's what I'm saying is take all those memos, whatever they submit, and whatever the office say, give them their memos, ask them to come at 2:30. Yes.
My lords, may I mention this matter, my lords? It was a fresh matter in which office objections were complied with in the month of November, my lords, 15th. We've also given 3 memos for posting, my lords. If your lordship may kindly grant us a date.
A copy and thereafter it was to be listed, my lord.
Day after tomorrow. Yes.
Maintenance case, my lord. The trial court has issued the NBW against the petitioner, my lord.
When was the order passed?
Order was passed in the.
Must have been passed long back.
My lord. No, my lord. This court has directed to serve the copy on the respondent, my lord. We have served the copy on.
And when was that order?
My lord, last month, my lord.
Huh?
Last month.
Last month.
NBW is issued, my lord.
We will see. Yes.
On Friday, my lords, your lordship, in fact,
The pending matter, my
serve
lord.
a copy to the respondent counsel and file a memo to that effect.
Madhya.
Lordship said it will be auto listed. It's not listed, my lords.
When did you file the memo?
Yesterday, my lords, yesterday. The order was on Friday. I served the copy on Saturday, filed the memo yesterday.
This is matter day after tomorrow.
Great.
My lordship.
Lordships, kindly,
Yes.
my lords.
Take that. Yes. Is it a fresh matter? It will come, yes.
My lordship,
Maybe, yes.
My lordship, the
Yes,
2021.
all, I am making, please comply with office objections, it will come, otherwise it will not come, yes.
my lordship, I am for.
I will not take up the old matters, yes.
My lordship,
I have
I
no
am.
time for that.
This matter
Yes.
is pertaining to child custody, my lordship. I have filed an early hearing IA, my lordship. The urgency is that, my lordship, the petitioner and the respondent both are Christianity, my lordship. The Christmas is coming.
For telling the facts, when is the writ petition filed, when is?
My lordship,
order?
it was filed on September, my lordship,
What
and
are
it
you
was
doing from
listed.
September to
No,
now?
my lordship, and it was listed, my lordship, and the date was given after list after January, my lord.
Because
Hence
you
the-
must have not been present in the court.
No, my lordship, we were present, my lordship. We were like my colleague was supposed to
A
take.
matter which a date is given in the month of January, why are you moving him?
My lordship, I have filed early hearing IA and intimated for the respondent advocates also, my lordship. The urgency is that, my lordship, both belongs to Christianity community, my lordship, and the Christmas is coming ahead, my lord. It will affect for the father and
It is urgent to January, what were you doing then?
my lordship. I have filed early hearing IA also.
Forgot in September
No,
that
my,
December
no, my lordship.
25th is
On that day
Christmas.
we were present, my lordship. It was regarding the memo which was filed by petitioner saying that the name of the respondent should be mentioned, my lordship. My colleague has came to ask for the course of the day, but mistakenly she took time, my lordship. In that regard, it was.
All these custody matters, it has become a fashion to just in the neck of the moment, file
Please, my
a,
lordship.
seek,
It was
move
not
a
an
memo
intentional,
and
my lordship.
some order or the other, the court will pass.
No, man. It was not an intentional, my lordship. As both are being.
If I'm able to
Please,
give the memo, otherwise I can't assure that the matter will come.
my
Take the
lordship,
memo.
because both are coming.
Yes.
Fall to Christian community. My
No,
lordship.
yes,
Much obliged.
no. No, no. I'll not take up this matters. Yes.
My lord,
Take that. Yes, next.
this is 2025 matter, my lord. This is a matter where this honorable court has directed for us to attend counseling before mediation center. We have attended the mediation counseling. She did not bring the child for a couple of times, and the counselor said, I will send the report. We checked with the pending branch. They say only if we move the matter, they will attach the report. And in my favor,
What is the order that is passed on that day? When it is directed to be listed, then only it will be listed.
no, there is no direction. Memo, post the matter when the counseling report is come.
What is urgency now?
Urgency is that, my lord, I have not seen the child since May. And that the same thing was mentioned before the court. I have also filed contempt petition in the same case. That is also kept in abeyance, waiting.
See, after vacation.
My lord, the only thing is I have.
No, already.
I have my
Please
visitation
understand,
rights.
already I have passed an order. She has not brought the child to the mediation center. Is it not? That's what you are submitting.
Yes.
In that case, you moved a contempt. Why should we pass another order now?
No, I'm only saying that I give a direction to let me spend the time during this winter vacation. That is all I'm asking.
No, she will not comply with that order. What will you do? She has already not complied with an order that's passed. No
Or
urgency
maybe
for that.
maybe
No.
the petition may be heard in on merits.
Get this.
My lords, please, my lords.
This matter was posted for 27/11 for hearing. It couldn't be reached. And it couldn't be reached on that day. There was no, and so there's no dates given. And
What is urgency?
Your lordship, this is with respect to the father speaking so ill about the mother and turning the mind of the child. And it is increasing day by day. And it was posted for the preliminary group final hearing only. And now it is so many other things also has happened. And I was supposed to do my argument on 27/11, your lordship.
We'll see after vacation. Yes.
Your lordship, kindly it may be considered, your lordship, because it's become so much that.
We'll see after vacation. Yes.
My lordship, we have complied this matter on 15/11, but it is not getting it, it is not getting it
To the
listed.
court officer. Yes.
My lord.
My lord, the father is not showing the children to the mother.
When is that petition?
25, my lord. Been 4 months. The date was given on 27th after the psychological evaluation of the mother and the children, my lord, which has been done. After that, it was not listed, my lord.
When was the evaluation?
22nd of November, my lord, last month.
My lords, MFA, my lords, owner's appeal, my lords, for stay, my lords, fresh matter, my lords. arrest.
But for being spoken to, my lord, there is a
Tomorrow, my
mistake, my
lords.
lords, in the.
That's already done
No, my
yesterday.
lord, this is another one, my lords, that your lordships have passed an order.
My lord, kindly
will-
post it tomorrow,
It
my
can
lord.
be
There
done
is
in
an
the chamber,
urgency,
not,
my
no,
lord.
no need to list it.
Please, my lords.
My,
The-
My lord.
my lord, kindly,
Printed of my lord.
Yes.
Kindly have it
My
on
lord.
Friday at least, if not tomorrow.
No.
my lord, kindly have it tomorrow, my lord. There is an
What is
urgency.
that?
My lord, respondent filed to release the amount, my lord. Respondent filed IA, my lord.
Take
Kindly
that.
have it tomorrow, my lord.
Yes. Call the list.
Page-wise adjournment. List number 2 for adjournment matters in the month of February 2026.
Yes.
List number 1, page-wise adjournment, page number 9, serial number 29 to 33, page number 10, 34 to 38.
My lords, I'm appearing for respondent in serial number 38, my lords. The petitioner has expired, so they have filed a memo in the trial court. So the petition has become infectious, my lords. It can be disposed of.
Increase the volume of, they're not able to be, why every day the volume is
No,
being
volume is-
reduced like that?
We have
Yes.
Serial number 46.1, my lord.
46?
Point 1.
Hmm.
Already complied.
It's the same matter, my lord. Yesterday, my lord, it taken.
Why are you mentioning it if you comply with the order, with the comply with the office objections?
No office objection ಏನು ಇಲ್ಲ
Then we will hear, please, we will wait till your matter reaches. Yes.
My lord, serial
ಅಲ್ಲ
number
2 weeks time.
Yes.
page number 13, serial number 47 to 55. Page number 14, serial number 56 to 65. Page number 15, serial number 66, 67. Page number 18, 16, page number 16, 69, 70. Page number 17, 71 to 78. Page number 18, serial number 79 to 82.
Yes.
Page 1 for serial number 1 for being spoken to.
Yes, Mr. Srinath, what do you want?
My lord, serial number 38, the petitioner has expired, my lords. I'm for the respondent in this case. The
Serial
petitioner
number?
Serial number 38, cause list 1, my lords. Basavaraj has expired, so they have filed a memo in the trial courts last week, my lords. So the petition has become infectious, so it may be disposed of, my lords.
It says IA number 2 of 25 for extension of time period.
Please,
Are you
my lord.
referring to 38?
Yes, my lords. 38. Basavaraj has expired, the petitioner. So the petitioner's counsel has filed a memo in the trial courts, my lords, 2 weeks back. So it may be disposed of, my lord.
What is that matter pending before the court? MC?
Diverse matters, my lords. Your lordships in the month of July was pleased to give a time limit to dispose of the main petition within 15th of this month.
The petitioner is no more, and already the same was informed before the trial court. Hence, recording the said submission, the writ petition is dismissed as abetted. Yes, next.
Right, my lord.
Page number 1 for being spoken to, serial number 1, Syed Abdul Sabur.
No, there are
Appellant.
matters.
Appellant in this case.
For respond number 2. Being spoken.
No, when it comes to this liability, you have the file with you?
No.
Then without file, why you have come to the court? Ask Pradeep to come.
Pradeep is out of station, senior.
List is matter on day after tomorrow. He'll be there.
Tomorrow, madam.
Tomorrow.
Please.
List the matter tomorrow. Yes.
For pronouncement of order, serial number 2, S.T. Bhagwan.
For respond.
This court do not find any reasons to interfere with the order passed and so and so. The respondent number 5 shall make her best efforts to secure a job within 1 year from the date of receipt of the copy of the order. The petitioner husband is at liberty to file a petition before the family court seeking modification of the order after 1 year from the date of receipt of the copy of the order, and by that time the respondent wife shall place before the family court what are all the efforts that are made by the wife to secure a job, and based on that the family court can pass appropriate orders.
Please.
Yes.
Sale number 3.
Disposed of.
Sale number 3.
Yes, Your Lordship, for the petitioner.
The bank shall pay interest on 25% of the EMD amount, that is an amount of rupees 22,28,750, interest at the rate of 9.95%. For the clear lapses on the part of the bank in informing the auction purchasers towards whom the bank owes a responsibility, shall pay an amount of rupees 50,000 towards costs.
Grateful. Obliged, Your Lordship.
Sale number 4. Sale number 4, Manjunath.
Respondent present.
That petition is dismissed.
Sale number 5, Rajendra.
Respondent.
For petitions.
The writ petition is dismissed as not maintainable with costs of rupees 25,000 to be paid to the Karnataka State Legal Services Authority within a period of 8 weeks from the date of receipt of the copy of this order.
Grateful.
Dismissal matter, sale number 6.
For the petitioner in this matter.
Raghu.
Hearing for the respondents in this case.
Yes. Who appears for the petitioner? Yes.
I am for the petitioner. in this
Yes.
matter. My lord, ಇದರಲ್ಲಿ brief fact of the case, my lord. Respondents ಗೆ ಇಬ್ರು ಮಕ್ಕಳಿದ್ದಾರೆ, ಇಬ್ರಿಗೂ ಕೂಡ
Please come to the impugned order.
Yes, my lord.
Come to the impugned order.
Yes, my lord. Just, there is no separate order in this case, my lord.
Then what is questioned before this court?
So, ಇದರಲ್ಲಿ my lord, that respondent number 1 and 2.
Call for the record in criminal miscellaneous number on the file of the family court.
Yes, my lord.
Order dated 18/8/2023 passed on INA. The order, what your question is?
I number
2. Where is that order?
Order is, there is no separate order, my lord.
Page 13 of the petition. ma'am.
Page?
Page number 13.
12, Your Honor.
Hmm.
I number 2 is allowed. Interim
There is an
maintenance-
order. Read it. Since the respondent continuously absent, read that. Read
The
that.
order is, my lord, page number 12, in the
Please
order
read.
sheet itself, Your Honor, my lord.
Please read.
I number 2 is allowed. Interim maintenance of rupees 30,000 each per month from the date of this petition is awarded. The respondent is hereby directed to deposit the arrears of maintenance within 3 months and continue to pay the same till disposal of the petition.
Yes, why you
on
did
merits.
not appear before the family court? Why you did not appear before the family court?
My father was died due to the cancer.
When did you file your wakalat? When did you enter appearance? When did he enter appearance before the family court?
Long back only.
My lord, I'm sorry, I'm not aware because I'm an
But those
NOC.
are all the details which are relevant for this.
My lord, 2 times mediation
Then I'll
has
set
been,
aside this order and give him an opportunity.
My lord, there's
Until
also,
such time, what about the interim order passed by this court?
it has been mentioned that the petitioners have paid an amount of 6 lakhs, which I have not received. And there's a pending amount of about 28 lakhs 20,000, my lord, till date, which is not being paid.
My lord, I am submitting some documents regarding the school fees and college fees paid by the petitioner as of now also. The respondent one
Yes,
is with the petitioner only.
The petitioner,
He's attained majority already.
the
This
petition
long
is
1
filed.
year, we paid more than 6 lakh to
Read by the
towards
orders
school
passed
fees and
in
college
number
fees, Your
2.
Honor, my lord.
In MC number, in criminal miscellaneous number
Criminal miscellaneous.
48 of 2022, dated 18/8/2023, whereby the court has granted maintenance of an amount of rupees 30,000 per month.
30,000 per child.
30,000 each per month.
Yes.
How many petitions are there?
2 children.
There's only one petition, my lord. There are 2 children.
Each to both the children.
30 to each. So 60,000 per
30,000
month.
each to both the children. The order passed by the court reveals that the respondent is, the husband is continuously absent. And the wife submits that the husband is working as an area manager and getting salary of rupees 2.5 lakhs per month. And the petitioner has 2 children who are minors. Therefore, in the interest of justice and equity, awarding maintenance is necessary. Hence, maintenance of rupees 30,000 each is awarded by the tribunal. Learned counsel for the petitioner submits that He has been paying the school fees. So far, he has paid an amount
Entire
of
expenditure now he is taking care, my lord.
entire
That's what
expenditure
I
is taken
filed
care.
receipts, your honor.
And he has filed, according to you, how much you have paid till now?
Till now, more than 10 lakhs we paid, my
It
lord.
is stated that he has paid more than 10 lakhs.
As on today
as
also,
on
I am
today.
submitting the school
My
fees
lord,
and
one
college.
submission, one submission.
1 year earlier, 6 lakh
I'm
code.
not considering all that. That's his submission. He submits that.
The mother of the
He has,
respondent is
paid
not
10
at all
lakhs
taking
as
care of
now.
the children.
He submitted that as on the day when the parents of the petitioner was unwell. He could not appear before the court, and the court, without there being any evidence on record, has passed this order. Land counsel appearing for the respondent wife submits that he has no instructions on what is the amount that is paid by the husband. As
The
he has
respondent
continued,
in her assets and
please wait, Mr.
kindly,
Counsel.
kindly. Oblige, oblige.
As he was continuously absent before the court, and he has failed to file his statement of objections before the court. The court had passed an order granting maintenance to both the maintenance at rupees 30,000 each to both the children. It is submitted that when he has failed to appear before the court and an order is passed, now he cannot question the said order before this court. Next, having heard the counsels on either side, that is the material on record. In this case, the court had granted an amount of rupees 60,000 basing on the statement that is made by the wife that he is earning an amount of rupees 2.5 lakhs per month. Admittedly, there is nothing on record. It is also an admitted fact that the petitioner husband has not appeared before the court. In those circumstances, the court ought to have granted some nominal amount as maintenance, but without evidence, the court ought not to have granted this amount of 60,000. When the wife is seeking maintenance, it's also her duty to place on record what is the income of the husband. In these circumstances, this court deems it appropriate to set aside this order. That order dated so and so, dated 18/8/2023, passed in IA number 2, and remand the matter to the court for fresh consideration. Within 10 days from by January 8th, both the parties shall file their respective statement of assets and liabilities before the court, and by 15th of March, the court shall dispose of the IA.
My lord, one submission, the assets and liabilities has already been submitted by the wife. And also there is pending arrears, my lord.
Let
Till
them
date,
file
nothing has been
So
paid.
it can't be at 60,000 without any evidence. Yes.
Cell number 7. Cell number 7, Suma, appellant.
For respondent number 1.
No representation on behalf of they move a memo, they don't appear. No representation, this is matter after vacation.
Cell number 8. Cell number 8.
Yes.
N. Krishnaswamy.
The insurance company appeal, my lordship. We are challenging the ground of liability, my lordship. Policy issued on 23/6/2022 and policy end date is 26/2023. Accident occurred on 24/2023.
Policy ended on
22/6/2023, my lord. So we are challenging the ground of the
accident taken place on what date?
24/2023.
24/2023
is a permit violation, my lordship. There is no permit at the time of the accident.
When the amendment, what is the date of amendment?
1/4/2022.
1/4/2022. This is policy is after the amendment.
Yes, my lordship.
The pay and recovery is ordered.
No, my lordship. Entire liability fixed against the insurance company.
The office has raised the maintainability of the appeal in view of section 173 of the MB Act, as the value of the appeal is 1 lakh. Land counsel submits that the insurance company is on the ground of liability. As such, the appeal is maintainable. Hence, office objections with regard to the maintainability is overruled. Next, stay petition. That is IA number?
1, my lordship.
IA number 2 of 25. The land counsel for the appellant submits that the policy is dated 23/6/2022 which is subsequent to the amendment. As on the date of the accident, there was no permit. In spite of the same, the court has fixed a liability on the insurance company, and the insurance company is not liable to pay the compensation amount. Hence, there shall be stay of all further proceedings on the condition that he shall deposit 50% of the amount within 4 weeks.
50% already deposited. 50% already deposited.
It is submitted that already 50% amount is deposited. There shall be stay of all further proceedings. Notice to the respondent.
Much
Number 9.
Yes, 9.
Shetty.
All of the petition has become infructuous.
Okay. It's coming up for the, any interim order in this?
No, nothing. No interim order has been passed.
There is a memo. See. The memo is filed seeking to withdraw the petition, stating that the petition has questioned the validity of the order passed in SA number 387 of 2020 dated 29/12/2021 by the DRT2 Bangalore. The respondent bank has auctioned the secured asset, which was questioned by the petitioner before this court, and the same is pending consultation. In view of the same, nothing survives for consideration in this petition. Accordingly dismissed. Memo is taken on record.
Number 10.
Matter is settled. The memo is filed stating that the matter is settled. That is not state. The petitioner has settled the matter out of the court, and she wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn.
Okay.
Yes, 11.
Number 11. That is also memo for withdrawal.
Yes. It is submitted that the red petition has become infructuous, and some memo is filed seeking to withdraw the petition. Memo is taken on record. Dismissed as infructuous. Yes, next 12.
Number 12.
Should I beg to appear on behalf of the respondent? I need some time to file my objection in this matter. It's the same matter, my lord. This matter court heard by.
Lord, senior advocate had addressed the arguments. Kindly it may be taken as part heard.
I don't have an
Is that
objection.
Lords, with respect to Malafite's valuation and
Lord, last Wednesday, my lord, this matter taken up on board at seal number 1. And my lord directed me to, my lord, place certain documents before this honorable court, my lord.
Oh, this is a
Same-
matter.
Same matter. I don't have any objection, my lord, to taken as part heard. I'll file.
Yes.
I may
This
permitted to
has
file.
parted.
I may permitted to file my
Request of
statement of
counsel for the
objection.
respondent, bank. Let's just matter after vacation. What
I
do
may
you want?
permitted to file statement of objection in this matter because we filed it only on maintainability. We file it and
The respondent is at liberty to file the objections. Let's just matter after vacation. Interim order is there.
Ide.
please,
Order
interim order may
earlier
kindly be
granted is extended till the next date of the order.
Number
Great.
13.
Great.
Any date when.
For petitioner,
Number 13.
my lord, I appear on behalf of the petitioner, my lord.
Yes.
Sridharma.
My lord, the family court, principal family court has been filed, given a representation, my lord, for extension of the time. This honorable court has given a direction till December 2015, 2025.
1
No,
minute,
my
the
lord.
letter is there. Just look at the letter. This court, by order dated 17/7/2025, has directed the family court to dispose of the case by 15/12/2025. Now, a letter is addressed to the principal judge, family court, stating its reasons why the could not be disposed of. As per the order passed by this court, and finally sought 2 months time, that is up to 15/2/2026, to dispose of the matter. Considering the same, considering the letter addressed by the principal judge, the matter shall be disposed of by 15/2/2026, and no further time will be granted. Party shall also not seek for unnecessary adjournment. Yes. Next.
Sale number 14.
Lord, I am appearing for the respondent in this matter, my lord. My lord, one submission before accepting this affidavit, my lord. We have agreed to close the loan at 1 crore 81 lakhs as against 2 crores 20 lakhs. My lord, we have given the breakups how it should be paid. That is not forthcoming in the affidavit, my lord. And still they say that.
Take that affidavit.
And still they say that they want to negotiate with this amount.
Let's see.
At para 4, they have stated.
First installment is 1 crore given on or before
One
20.
minute. Let me just go through this. Where did you say about how you are going to pay the money?
Last page is there. They have given a letter, last page, fourth page.
No, when you're filing an undertaking affidavit, in that affidavit, all these details should be there, that on by so and so date, I'll pay this money.
They are given a letter, mail sent, page number 4.
It is not about their letter. It is about your undertaking.
First,
You have to say so here. Where did you say?
First installment has been 1 crore on or before 25/12. That is
Please read paragraph number 4.
I further submit the respondent bank has agreed to for the OTS settlement, and the petitioners are ready hereby undertake to pay the OTS amount with further negotiation.
What is that?
Further negotiation means first installment is 25/12, 1 crore. That is only a negotiated with.
Petitioner has filed a undertaking affidavit stating that they will further negotiate with the bank. That cannot be accepted.
I will close
the
the
petitioner wants this matter wants to settle the matter and to dispose of the matter on the said terms. He shall file a better affidavit disclosing the amounts when he is going to pay. Then basing on that, orders will be passed. This is matter day after tomorrow.
interim order may be extended.
Interim order earlier granted is extended till. Yes.
First, I appeal for the respondent. Section 13(2) notice has been challenged in this writ petition, and an interim order was granted for payment of 10 lakhs. That they have paid in September 2024.
What is outstanding?
Plus outstanding is 60,75,912 as
No representation for the petitioner. This is matter for dismissal tomorrow.
Number 16.
Respond number 1. Matter, my lord, last occasion, this honorable pass and detail order. Now, my lord, they filed one more interrogatory application. However, my lord, we are ready with our submissions. In fact, we synopsis and my lord, it's the same matter. There are 2 writ petitions. The first writ petition is concerned, my lord, classification of NPA, my lord, essay. The second writ petition, my lord, based on the MSME guidelines, my lord, they came before this honorable court. In fact, my lord, kindly see the order, my lord, passed by this honorable court on last year.
My lords, one submission, my lords. The advocate for petitioner is undergoing gear operation today at Victoria, my lords. Kindly praying for a short accommodation.
It's all.
Lords, in fact, the previous date, your lordship
interim
had
order may be
ordered
vacated,
that
my lord. It is, my lord.
no further adjournment should
considered
be granted.
Before this honorable court will not precipitate the matter, my lord, matter.
In fact, I sold a property, sale certificate issued. My lord, we are not in the position to, my lord, hand over the position of a property. My lord, it is some urgencies involved in this matter.
No,
Well, so we-
right from like how, no, that some inconvenience to the council I can understand. But the matter, how the manner in which the matter is proceeded, there is, I think no indulgence is required. You please make your alternative arrangements.
Lord, apart from
Now, when the matter comes up before the court, you say that the matter, this court has no roster. It has to go before GMRES. And when the court says that this court has roster, then you will file a memo saying that you pass orders on the memo. I will question it before the division bench. What happened?
They have not done.
They have not taken any steps, Your Lordship.
Lord, I'll just.
Have you questioned it before the division bench?
I'm not aware of that, my lords.
Lord, kindly see, my lord, how many
This is
adjournments were
nothing
taken?
but forum shopping. What is the difficulty of the advocate to argue before a court and say that no, I'll go and argue before some other court?
My lord,
And
this-
I made it very clear on the last occasion. When this court has asked and counsel for the petitioners to go ahead with the matter, as this court is having roster to hear this writ petition, it is submitted that he wants to question this order passed on the memo. The whole endeavor of the petition is to drag on the proceedings one way or the other, so that the bank will not be able to take any further step. This court do not find any reasons to consider the memo that is filed by the petitioner and accordingly rejected. List this matter on 17/11. On the day, this court will hear the matter on the merits of it and no further adjournments will be granted. And at that day, I made it very clear that next time I will vacate the interim order. Now, a writ petition of which year?
2021.
2021, you get an interim order in 2024.
That too, my lord, we conceded on that day, my lord, we'll make a submission before the next date of hearing. In fact, thereafter, my lord, every date, my lord, they come before this honorable court, take an adjournment. In fact, we have filed a synopsis.
I will take up this matter on Friday. Please make whatever alternative arrangements you can make. It can't go on like this. List this matter on Friday.
My lords, let the interim order be vacated,
Vacated,
my
my
lords.
lord.
Friday we will do it.
Grateful. In fact, we already placed our synopsis and my lord compilation.
I know, understand. We'll give them an opportunity. Somebody will have to engage.
There are 10 adjournment, my lord.
No, that is true. She says some difficulty to the advocate on record.
I would.
Yes.
Cell number 17, Sustaba H for petitioner. Memo for repayment.
Okay, for the petitioner, please. My lord, during the pendency of this writ petition, my lord, I have discharged the entire loan, my lord.
Discharge the entire.
Settled, man. I have discharged and discharge deed is also executed, my lord.
A memo is filed seeking to withdraw the writ petition. It is stated that the petitioner has discharged the entire loan and the loan account is closed. Petition scheduled property is released from mortgage and a cancellation deed dated 15/11/2025 was executed by the bank. Hence, nothing survives for consideration. Accordingly, the memo is taken on record. The writ petition is dismissed as instructions.
Cell number 18. Cell number
Lordship.
18.
Yes.
Lordship, kindly peruse, I have filed 3 IAs. IA number 2, your lordship. The earlier occasion, lordship were pleased to pass the interim order. At page number 9, your lordship. IA number 2.
Counsel for the petitioner submits that the vendor of the second respondent had no title in relation to the mortgaged property, which is evident from the order passed by the division bench of this court, entered appeal and confirmed with the Honorable Apex Court in SLP number. Therefore, the second respondent had no title over the mortgaged property. Second respondent has mortgaged the property in favor of the bank.
Thank you, lordship.
And even till now, there is no notice is served on them.
No, we have personally served on them. That is at page number, your lordship.
Who appears? Anybody appears for Aditya Birla Finance?
No.
Advocate?
No, we have personally served upon them, your lordship. That is at document number 2, your lordship, at page number 8 in the same document.
And that's what I'm saying. Any counsel appears.
No, they don't want to come, your lordship. We personally went to them for 10 times.
Why this? Why this is moved now?
Your lordship, they have a notice has been made at page number 4, Your Lordship, e-action notice. So that is the reason we moved it, Your Lordship. So without title, they are proceeding. Yeah, day before,
What is the interim order? What is questioned in the writ petition?
question is that the borrower does not have the title. Borrower
Order is as prayed for. What is the interim order you saw?
interim order is that pending disposal of the above writ petition, the Honorable Court be pleased to stay all further proceedings in pursuant to the impugned order passed in criminal miscellaneous, so and so. So
Why another interim order is required?
No,
when
that Your
when all
Lordship.
proceedings are stayed by the
Yes,
court?
but my humble submission is that, Your Lordship, at IA2, page number 8, Your Lordship.
No,
Page number 4.
I understand that they've issued a sale notification. There is an interim order
Yes,
already.
I agree.
So where is
But
the question of
technically-
granting another order now?
Technically,
Because by this order, they cannot proceed with the sale.
Sale.
Because there is stay of all further proceedings
Yes,
pursuant to 14 order.
Yes.
So why should we pass another
So
order
my
now?
humble submission is that some officer has been colluded with these people. My client has went 10 times personally to make them to participate in the court proceeding.
No, everything they'll be doing at their cost.
Yes,
So if you file a contempt petition, that has to be pursued. No repeated orders, what is the?
no, my humble submission is at page number 4. If that is not clarified, Your Lordship, I am before this. It is brought to my notice now. It has been affixed on my property. It has been affixed. It is in my knowledge. What I am supposed to do, I has to come before the court pending proceedings. I has to bring to the notice of this honorable court. So what I am submitting is a clarificatory order can be made, because here what he says, in spite of this, everything is stayed in the public notice for e-action, possession which has been taken by the authorized officer, it has been stayed. Now with this fresh publication, they say that everything, they are misleading. So
What happened to the contempt that you have filed?
now contempt, we are moving it, Your Lordship.
You're not at mood.
Not at mood, because it was.
That should have been done first than this.
No, we got it now. That copy was not available to us. It has to come before quota number 1, Your Lordship. We will move it, Your Lord. And we made a police complaint also.
Oh, it is like order 1, it has not worked out. Order 2, again we will pass another order. There is no, sir.
No, but I will be at very great risk, Your Lordship. Your Lordship has not passed any order.
Not at all at risk, because you have an order. Bank is at risk by not implementing this order.
No, I will make it sure, so that here what says, Your Lordship can consider this. The very possession order has been stayed.
Have you issued a notice to the bank?
Yes,
Where is
that is there, Your Lordship, at page number 8, Your Lordship.
Page number?
8.
8 of what?
IA2, Your Lordship. So when we met the author, the signal, we got it, personally we got it, Your Lordship.
Page number?
8, Your Lordship. Document number 2. IA2, it is marked in IA2, Your Lordship.
No, I'm looking at IA2. IA2,
Is
page
first.
number 8 is interest bidders, something.
No, Your Lordship. IA2, that is where I have sought for the interim order, document number 2. Document number 2. That is interim order. On the top of that interim order, it has been, the manager has received personally, Your Lordship. From the court also, it has been served. We took the emergent notice from the court, it is served upon them, and also hand service is also, we have sought from this. What I am submitting to this honorable court.
Show it to him, where is it? Take this. Take this, give it.
typed copy. Number 14.
What is this?
Top of that, Your Lordship, we have
I asked you, have you issued a legal notice to the bank?
notice, we have issued, we have
It
issued.
is not there.
It-
That's what I was asking.
On the upper side, Your Lordship, it has been personally served because we have taken the hand service.
I'm asking when they issued when they fixed that sale notice on your property.
Yes.
Have you issued a legal notice to the bank saying that in spite of an interim order by the court, you are still proceeding with it?
My client has went and informed them, and nobody is willing, because the whole issue is that, Your Lordship,
You can send it by post,
yeah, will
isn't
make
it?
my humble submission is that because it is not like a public bank, nobody is responding, Your Lordship.
Notice will go.
Yeah, we
by-
will make it.
from the.
He has personally went, whole family has went to the bank, Your Lordship, along with his aged father, to request them to come before the court. So in spite, we got the order in the SLP. So my humble submission is that this will compel them to come before this court, Your Lordship, so that
It will not compel them. What they, when they don't want to come before the court, they will not come.
no.
The,
Now-
the remedy for you is the contempt, not passing successive orders. Like it is like it doesn't make any sense giving another order when already there is an order. Not they have not complied with that order.
No, we will move it,
So-
Your Lordship. We'll make it. But Your Lordship very well knows, any subsequent orders, I has to come before the court and get some orders.
Section 14, all further proceedings pursuant to section 14 or state.
That-
Sale notice is pursuant to section
Correct.
14. So that is also stayed by
Yes,
one
yes,
order.
I agree.
So why are we passing successive orders? That's what I'm saying. You have an order in your favor.
Yes, yes, Your
No
Lordship.
further orders are required.
But what happens, Your Lordship, if Your Lordship passes some order so that
This is also passed by the lordship.
yes, yes. In regard, the whole issue is that maybe that this is an independent procedure. They may thought that it.
That is not there for their understanding.
Yes.
We are not. It doesn't. We shouldn't pass this kind of orders. Please come. Lencom, the IN number 2 is filed stating that the bank is proceeding with the public auction. Hence, there shall be a direction to the bank not to conduct the auction. The writ petition is filed in the year 2024, stating that the second respondent who has mortgaged the property to the bank, to the first respondent, has no title to the property. A coordinate bench of this court on 12/12/2024 has passed an order observing that it is a contention of the petitioner that vendor of the second respondent had no title in relation to the mortgaged property, which is evident from the orders passed by the division bench of this court in writ appeal number 1325 of 2005 and confirmed with the Honorable Apex Court in SLP number 27617 of 2012. Therefore, the second respondent had no title over the mortgaged property to offer it as security for repayment of the loan. The court has issued emergent notice and granted interim order as prayed for. The interim order that is prayed in this writ petition is there shall be stay of all further proceedings pursuant to the impugned order passed in criminal miscellaneous number 50401 of 2024 dated 2/9/2024 passed by the magistrate under section 14 of the Surface Act. When the court has stayed all further proceedings as per the order dated 12/12/2024, the respondent bank, as per the submission of the petitioner, is going ahead with the auction. In the considered opinion of this court, the bank is doing all this at their risk, and at this stage, there cannot, as already further proceedings are stayed, question of passing another order, staying the auction will not arise, as this order will, the order dated 12/12/2024 binds the respondent bank, and even as per that order, the respondent bank cannot cannot put the property to auction. It is submitted that the petitioner has already is taking steps to move the contempt. The petition is at liberty to do so. Yes.
Your Lordship, interim order may be extended.
In the interim order earlier granted is extended till the next date of year.
And one submission, Your Lordship, at page number 4, in spite of this is apart from this matter I am bringing to your notice. The possession has been stayed, Your Lordship. In spite of that, the e-action notice says the possession has been taken.
What I'm saying, he cannot do it. So in the first order itself, what he is doing now
Yes, is
is
at his wish.
stayed. So
But
second stay order will not grant. Yes,
interim order is extended.
after that. Interim order earlier granted is extended.
Much of.
19, SV Bhatt.
This is yesterday's matter which had come up. They had sought for some time yesterday till today. It's a matter where, my lord, the sale notice was challenged. I am the auction purchaser. Subsequent to orders being passed by this honorable court, my lord, we have already gotten the sale certificate registered. Thereafter, my lord, I filed another writ petition for Khata to be issued in my name. That's also been issued. I'll just place all of that on record because the writ petition becomes.
Is it a copy of category? What is the relief that is sought in this writ petition?
As against the sale notice, my lord.
This was filed challenging sale notice, my lord, at the first instance.
Mm.
My lord, during the pendency of this writ petition, they have gone ahead with the sale and sale certificate has been issued. For that, an application for amendment has been made.
No.
That application,
Now, why you are before this court? Why you shouldn't go to the tribunal, the DRT?
the reason being, my lord, is that the property which is sought to be sold, my lord, is a commercial property measuring about 24,000 square feet. They wanted to sell it, and in the sale notice, the reserve price that has been fixed was in respect of, based on a valuation report which they have produced it, the bank has produced it along with their statement of objections. The total area, constructed area is about 24,000 square feet. Valuation that has been made is for 13,500 square feet as per the valuation report itself that they have produced now before this honorable court. Based on that, reserve price has been fixed. That was totally contrary to even the mortgage deed also. They have produced the mortgage deed itself. Even in the mortgage deed, the area mortgage, the property that has been mortgaged is the property with the building measuring about 24,000 square feet. However, valuation is taken only for 13,500 square feet. Based on that, reserve price has been fixed. They have gone ahead with the sale. That was the first crucial mistake that they have made. That is what I have brought it before this honorable court. In fact, they themselves have produced that valuation report, which your lordship would get it at page number 187. My lord, this is valuation was made on 13/7/2024 after the possession notice.
Where are the objections?
My lord, I filed objections, my lord. And prior to that, my lord, the judgments of Honorable Supreme Court with regard to challenge the sale notice before the Honorable High Court, when we placed one judgment.
But the problem is the bank should be fair. And first of all, if your conduct of the bank is questionable, as he says, we will not go into what is the law. First, you have to clarify on facts. Then you can tell the court that the court cannot go into all these issues. When they are saying that there is if the property is so and so extent and showing half of it, and if you sell the property, where will the party go? Why should he go to the DRT? Why not?
No, my lord, the statement made by him, which is
And
incorrect.
then you please tell how it is wrong. Where is from where you get that?
187.
Page number?
Page number 187 is statement of objection R15.
187 of their objections.
Yes, ma'am. This is the valuation registered valuers valuation report. Let page number, next page number 188. May kindly be 8. The report.
Equivalent built-up area 13,590.
13,590. For that, valuation is fixed at 13 lakh 40.
Where will you get that?
61 lakh. Page number 189. 13 crore 61 lakh 26,000 was the valuation that has been made. Based on this reserve price in the sale notice, your lordship may kindly see the sale notice. Sale notice which is challenged by me. It is at annexure A, page 15.
15 of the repetition.
Yes, ma'am. It starts at page number 15. Page number 16. Third paragraph, the highlighted paragraph, the authorized officer.
14 crores.
Yes, my lord,
Hmm.
14 crores.
Where is the mortgage deed?
Mortgage deed, your lordship would get it at page number, along with the statement of objections.
Hmm.
They have produced it at page number 58. Start at page number 54, my lord. 52 is the stamp, then 54 is the mortgage deed. Then schedule, your lordship would get it page number 62.
50?
62. There, all piece and parcel of the immovable residential property bearing number 1960 square feet, so and so. Then another property, they do another property measuring about 6,040
No, let's,
square
let's,
feet.
let's calculate.
There are two. Then, my lord, your lordship, tell you. Yes.
What is this extent?
There are two properties, my lord, which have been
I am
mortgaged.
at page 62.
62, my lord. 24,415.
24,415 is one.
This is the second property
Uh,
on 11th Cross Road, 11th Cross Margot.
Is it the one mortgaged?
Ah,
I mean,
this
is
is
it
the
the one auction?
Yes, this is the property that has been auctioned.
And what was the valuation as on that date when the property?
As on that day, my lord, according to me, it is about 30 crores, my lord.
No, when was it mortgaged?
It was mortgaged in 2018, my lord.
Hmm.
Valuation is taken in July 2024. Sale has taken place in March 2025. By that time, my lord, there was a revised guideline value also. As per that, it was about nearly about 30 crores. It is a commercial property, my lord, having various multinational companies are tenements there also. It is a ground plus 4 floors on main road itself, measuring about 24,000, having all facilities. In the sale notice, the facilities that is available, nothing has been mentioned. They don't mention even about the tenants in occupation. They are all residing there based on the registered lease deeds. Nothing is forthcoming. Nothing is stated.
We'll ask them. Yes.
Please.
My lord, in this case, my lord, as far as the valuation is concerned, my lord, they have taken the valuation for the permissible area. 2.25 is the permissible area. According to the master plan. Extent. 2.25 is the permissible building. FIR is the 2.25, that is the permissible area. My lord, accordingly, the valuation has been made. As far as the master plan, the permissible area is 2.25. I will place that the circular master plan circular before this honorable court. If such being the argument, my lord, I am permitted to place that circular.
Sale certificate is
Maybe
issued
taken
for
up to
24,450 square feet.
What is that then?
Maybe taken up tomorrow. I will place that the master plan circular before this honorable.
Answer to that, if permissible area is auctioned, permissible area should be shown in your document.
My lord, 2.25, whatever it has been constructed.
You have given it for 24,000.
Yes, my, according to my the instruction, whatever the over and above which has been constructed, it is as against the contrary to the circular.
Why did you mention it?
Circular.
For the purpose of selling the property, it should be 13. For the purpose of giving the title to the purchaser, it would become double that.
My lord, the permissible area only we have to take while valuing the property.
Mention the permissible area in that.
I may be permitted to place that circular. Kindly take up this matter tomorrow, my lord. I may be permitted
Please
to place.
come. The land counsel for the petitioner submits that when the property that is mortgaged to the bank is.
May I make a submission clarification on this, Murad, because I was.
No, it's for the bank to clarify, not for you.
Because this was also subject matter before the coordinate bench when I had sought for registration, Murad. So there, what they show here, Murad, is 13,500 square feet insofar as FAR is concerned, just to show what it is. Thereafter, Murad, the sale certificate was placed before this honorable court because the coordinate bench of this honorable court, considering that this is the 7th writ petition which was suppressed, they came before this honorable court for the 7th time. They had not complained. I understand.
What the petitioner, what are the lapses on the part of the petitioner will concern.
Please.
As far as the bank is concerned, bank should be fair in its.
Please. So this was also placed on record, Murad, before the coordinate bench.
No, you please tell the court now you want to clarify.
Please.
No, you say that whatever permissible is 13,000 square feet, that's why
Please.
they have mentioned it.
Please,
If that is permissible, in your sale lead also, in your sale certificate also,
Please.
it should be mentioned as
my
13,000.
lord,
Why
that
it
is for the purpose of
24,000?
valuation, my lord, because so FAR is looked into, my lord, because 2.5 is the permissible FAR. Based on that, my lord, I'll just go through it. I'll just take my lords, my lord, because that is different. It's not, it cannot be the built up area, my lord. I'll just take my lords to that. It is equivalent built up area as per FAR 2.25, my lord. Only for the
Where do you
FAR
get that?
2.25. My lords, may kindly see
In the
page
valuation,
80 188 itself. Equivalent built up area. It is not the built up area. Equivalent built up area for the FAR.
Come to that, page
Please.
number.
188, my lord. It is only the equivalent one. It is not the FAR, not the entire square footage. This is only for the purpose of valuation. It cannot be for 24,000 square. That's the entire super built up area. This is based on FAR, my lord, because for any plan sanction also, when any developer is putting up anything, the permissible FAR is only this much. So
where is
for
the-
the FAR,
Where is a valuation certificate as on the date when you have given the loan to him?
That valuation, we still we could place it
You
before
can
the,
place it.
because this,
before the court.
because this cannot be the
But
controversy
even,
here, my lord. Please.
even otherwise, my lord, he himself has produced the valuation certificate. What is the, my lord, the price arrived at? The price arrived at is one,
Land counsel for the petitioner.
what,
submits,
21 crores is the price arrived at.
The property that is.
My lords, may
mortgaged
kindly
to
see
the-
189 towards the end. It's there,
Tomorrow,
my lord.
I'll take it up
My
tomorrow.
lord,
Let them place
189,
it.
I'll clarify right now. 189 at the bottom. At the
180?
bottom. At the bottom, 189 at the bottom.
Yes.
Last point, as per the provided details, the subject matter is having BUA of 21,415 square feet as per FAR 2.25, arrived BUA as 13,560. It is right there.
What was 2018, a property which was 30 crores valuation?
It was not so much.
So let's
My lord,
see the
he himself,
valuation
he himself has produced valuation certificate before
Where
the
is that?
court. My lord, the petitioner, kindly see the annexure E, ink page number 52. Ink page number 52.
Yes.
My lord, according to him, the valuation is 21 crores, 16,000, 16 lakhs 57, that is ink page number 56. According to them, my lord, the valuation of the property,
For what it is, no, the price that is offset price is 13 lakhs.
the 13 crores, the reserve price is fixed.
14 lakhs, reserve price is 14 lakhs.
14 crores.
The property was sold for more than 20 crores.
I
in this
paid
matter.
20.12 crores. my lord,
20.12 crores. Not that, my lord, the reserve price is an indicative price. That is not the price, my lord, where they have, that is the indicative price. They have to start the bid from the reserve price, that the indicative price. It may go up. My lord, I cannot sell the property below.
It's the reserve price.
My lord, the reserve price.
My lords may see 190, my lord. 190. 190, my lords may kindly see the first point as there itself. 23,000 per square feet.
23,000 per square feet. My lord, the valuation is similar. My lord, I have not taken the lesser valuation. My lord, the valuation which he has given before this honorable court and the valuation which we produced before this honorable court is almost indicating the same. 21 lakhs, he is telling that his writ petition is telling that the property is more than 20 crores. Now, my lord, the adding to that, it is an afterthought. He is before this honorable court and claiming that the property is worth more than 30 crores. I am permitted to read his the writ petition amendments, my lord. What he has stated in the.
The property valuation is 21, you should, the reserve price should start from 21.
That is
Why
his
should it be
valuation.
14 crores?
My lord, that is his valuations. That is his.
So what is the bank's valuation as on the date, when you have given him the loan?
When you have given him the loan, that valuation I am permitted to place before this honorable court, my lord. We have taken the valuation.
My lord, may
This is
request day after
matter
tomorrow.
tomorrow.
my lord. I'm not here tomorrow. Day after tomorrow.
This valuation
This is
certificate,
matter
what
day
I have
after
produced is
tomorrow.
of
By the time
2015.
the bank shall place before the court, the valuation as on the date when they have given the loan to the petitioner. Yes, next.
Please.
Number 20. Say number 20.
Short Passover, my lords.
Today Passover is not
No, the
possible.
matter was posted for 3:30, my lords. In fact, the senior is before the other court, my lord.
Where is it posted at 3:30?
Lords, it was the my lords may see the order sheet, my lords. It was posted for 3:30, but it's coming the regular list. my lords.
Let's see, where is that? Where is it said it is at 3:30?
Senior is before other court, my lord, the only reason.
My lord, 100 crores is outstanding, my lord, and matter has been going on several times. Matter has been adjourned from time to time at their request. All that they are doing, my lord, is
We'll take it up this matter day after tomorrow, 3:30.
Please, my lord.
Because today I have a bench in the
I know,
afternoon.
I know.
This is matter day after tomorrow. Why it should be 3:30 special treatment? This
Last
is
convenience.
matter day after tomorrow. Yeah, don't say 3:30, 2:30.
Please.
I generally don't give this 2:30, 3:30 business. Why it is, I don't know.
The last date of hearing, my lord, so my lord's heard for
Huh?
heard for some time and thereafter, my lord's posted
Yes.
for 3:30. Grateful.
Your lordship, day after tomorrow.
Cell number
Yeah.
21. Cell number 21.
And in this
Waiting
case,
for the respondent. in
as
this
per
matter.
the,
Naveen Kumar.
as per the direction, my lord, I had filed one more better affidavit.
My lord,
Have you given her?
one submission, my lord, in this matter? In this, like it is, they said 8 tenants are living. With great difficulty, we have taken the possession, my lord. If they put them back in the possession, my lord, if they default in paying the installment.
No, that's what I had stated in my affidavit, my lord.
My lord, he just said that voluntarily he will hand over the possession. That
What-
will
what
not
else
serve
to
the
be
purpose, my
stated?
lord, because the tenants, we can't evict them. Unless
Already
they
you have
file the
evicted.
affidavit
Already
saying
it has
that
been done.
they will
No, then
voluntarily.
what we tell them is, let them not induct the tenants into it
Please, my lord.
till the
Please,
entire
my lord.
process is completed.
My lord, even after paying 1 crore, my lord, out of 2.92 crores, my lord, the restoration should happen, my
But
lord.
as far as your property, your possession is concerned, it will be restored if you are staying in that.
My
Not
lord,
for the tenants.
my
We
lord,
can't.
admittedly,
So
my lord,
when
the,
when, as per this affidavit, when the entire payments will be completed?
On
no,
or
yeah,
before
the date is not changed, my lord. Even as per the,
February, they will give the.
yes, yes, my lord, my lord, my lord. That is not the,
Take the position.
that is
but
not
don't
the
induct
intention of the entire proceedings, my lord. My lord, my humble submission is that you may read the para 3 of my better affidavit filed, my lord, on,
Where is the affidavit?
my lord, that is filed on 11th December, my lord. 10th, this matter was came up before this honorable court.
Hmm.
The very next day, the better affidavit has been filed.
Yes.
May I read para 3, my lord?
What is the nature of the property?
My lord, it's a residential premises, my lord, comprising of 8 tenements, my lord, and out of,
Hardly, it's just a matter of 2 months. We are already, December is complete.
my lord,
January,
that's so,
So what?
my lord, the
what will be
entire
the-
endeavor of the petitioner is to place the tenants back into possession, my lord.
How much rent you get per month?
My lord, it is on the lease basis. That is the problem for the petitioner, my lord. If he is getting on rent, my lord, it was not difficult. My lord, the tenants who have been now being to put to the possession are on lease basis. The petitioner is not able to pay them the lease amount also.
Were they evicted?
My lord, on 29/10/2025, my lord.
So from the last 2 months, they are not in possession.
Not in possession, my lord. They are living in a lodge, my lord, with the family, my lord. That is the difficulty, my lord. Hence, my lord, I have undertaken to pay 1 crore.
Come to the affidavit.
Please, my lord. Page 3, para 3 of the affidavit, my lord, in page 2. That I am undertaking that after the payment of first installment of rupees 1 crore and restoration of physical possession in my favor, and in case of default from my end to pay the second installment, the physical possession of the scheduled property will be voluntarily delivered back to the respondent bank. My lord, this is in continuation with the first affidavit, my lord.
That's his responsibility to do it.
Please, my lord, please, my lord.
Lord, what
And
happens?
moreover, my lord,
No, he is paying the amount.
No, he
And-
is paying the amount. I'm not, my lord, we are agreeable for that. The practical difficulty for the banks, what happens, my lord? One installment they'll pay and they'll take back the possession. And they'll induct the tenants. As he said, they are on lease. Even if they are on lease, it will become even more difficult. Unless he pays their money, they will not vacate the premises. And again, we have to go for go and file a section 14 petition, and then again we have to obtain the orders, my lord. First order, whatever we have executed, it is gone. We can't act upon this. We can't take action under the same order. That is the problem faced by the banks, my lord. That is the reason I'm requesting this honorable court. Let the tenants also file
Lord,
the
even-
affidavit before this honorable court. What is the difficulty filing the affidavits, my lord,
affidavit?
of the tenants?
Lord, they are not party to these proceedings. That is first thing.
But they are
Second
in
thing,
the
my lord,
premises. They want
earlier,
to
my lord,
induct-
when I had filed the affidavit, The bank insisted to insert this clause, my lord. I had inserted it.
That day
Even
also,
now,
it was
the
my
bank is
specific submission.
insisting. Now, my lord, let us forget all this, my lord. Come to the action conducted in spite of the interim order granted by this honorable court, my
I'm
lord.
not going into that aspect.
My lord, then, my lord, this court is not honoring its own orders, my lord. Very sorry to say this. The own interim order granted by this honorable court is not adhering to, my lord. In spite of that, my lord, in spite of communicating the interim order, my lord, the very next day, even communicating the certified copy of the order, the bank officials have the guts to say that it is the duplicate copy.
My lord, this is the.
In spite of bringing all these facts to the notice of this honorable court, my lord, and I have filed one more application also, my lord, seeking to amend the writ petition, my lord, wherein I have sought the prayer to cancel the declare that action as null and void, my lord. My lord, that application is pending for consideration. And in spite of, my lord, as per my undertaking, my lord, the undertaking given by the petitioner, my lord, he has filed the second affidavit. It is not the first affidavit, my lord.
Two aspects.
Please, my lord.
One is you want an order on the undertaking or you want an order on the merits of it. If you
My
want
lord,
an
if-
order
if
on the
they-
merits of it, you please argue,
My lord-
I'll pass orders. I'll consider all that order passed by the coordinate bench, what is not complied with them, and I'll pass an order. There are two different ways.
I
Please
do
don't
consider.
mix the two.
I am not mixing, my lord. I am not mixing. When my learned friend is insisting on still more.
It's fine because they can, because it's an, they have also to accept and I have to also record the reasons. So if you're ready to argue on the
My lord,
merits of it, you
as
argue, I
as
will
per the direction of this honorable court, my lord, I had filed my better affidavit, my lord.
No, but you have gone to
Kindly consider this.
But you are not, you have gone to the some other.
No, no, no.
Your argument is
When
on
my learned friend,
your order not.
my lord, when my learned friend has insisted to file the affidavits of the tenants, my lord, I had raised that issue. Otherwise, I am not mixing anything. Now as per the direction of this honorable court, my lord, the better affidavit is before this honorable court, my lord. Kindly pass the orders on that affidavit, my lord, and also I seek to take it on record the application for amendment filed by the petitioner, my lord. Last time also I had insisted, but this court has told that this better affidavit be filed, then we'll consider.
Not acceptable to them for that because you have not, they want an undertaking.
My lord,
from the please listen to the court.
Please. Please.
That is not acceptable them. What is not acceptable to them? Because that is not for this court to pass any order. Now I will pass orders on the merits of it. You please argue on the merits of the matter. I will, whatever that amendment petition, that also I'll hear. You please argue on the merits of the matter.
My lord, before that, my lord, I insist to pass an order, my lord, based on the affidavit, my lord. Because, my lord, as per the instructions of this honorable court, my lord, directions of this honorable court, I had filed 2 affidavits. It's not that I am flying away or shying away with anything.
They have said what is the difficulty that the court understood.
My lord,
So then I
based
ask
on
you-
that difficulty only, my lord, the better affidavit has been filed.
No, on
Earlier,
the-
my lord,
on
when the first affidavit has been filed, they said that no, what if they default? That default clause, my lord, has been I have undertaken in para 3 of my better affidavit.
Yes.
Considering that, my lord, orders may be passed is my
No,
humble
no,
submission.
that's what she is saying now, that it is
My lord,
difficult for
if-
them to vacate the tenants because they are on a lease.
My lord, on 29/10/2025, when the entire property has been vacated, they were on the lease also. It is not that for the first time they are in the lease. They were in the lease as on the date of taking physical possession.
So please come to the writ petition and argue on the merits of the matter.
My lord, if I may insist, my lord, to pass the orders on this affidavit, my lord.
But you were saying about.
I am
Now
not
will
saying, my
pass
lord,
orders.
I am not saying.
Pass orders on the
I am
merits of the
saying,
matter.
I am
on the
seeking this
interim
honorable
order
court's intervention.
That is passed by
I am
this court.
seeking,
On the violation of the interim order by them, all these things will be considered.
my lord,
What-
I'm
Come up with an argument.
today,
Please
my lord,
continue and take it
today
to a
I-
logical end.
I'll take it to the logical end, my lord.
Argue
But
then.
today my endeavor would be only to say, take a suitable orders, my lord, on this affidavit, my lord.
I will record that. Please come.
Please, my lord.
The memo is fine. by the petitioner.
Affidavit, my lord.
An undertaking affidavit is filed stating that they are ready to pay the amount that they will deposit the amount to the respondent bank, an amount of rupees 1 crore on 25/12/2025, an amount of rupees 1 crore on 25/1/2026, an amount of rupees 1 crore on 25/2/2026. And the final payment shall be subject to the respondent bank providing the loan account statement and the exact amount that would be due as on that date. And an undertaking that after the payment of the first installment of rupees 1 crore and restoration of physical portion in favor of the petitioner, in case of default from the petitioner sent to pay the second installment, the physical portion of the scheduled property will be voluntarily delivered back to the respondent bank. The land council appearing for the respondent bank submits that there are about 8 tenants living in the said property. Before now, the petitioner is seeking the restoration of the possession after the first installment is paid. It is submitted that if the possession is restored, and as all of them earlier also for taking a portion, they have to make a lot of efforts. And now, if once they are inducted, it would be if the remaining amount is not paid by the petitioner as undertaken by this court, it would be difficult for them to take the portion. Land council, it is submitted by the land council appearing for the bank that the tenants who are in possession of the property may also file an undertaking before this court that they will deliver the portion of the property to the bank in case there is any default on the part of the petitioner. Land council appearing for the petitioner submits that he has already filed one affidavit earlier. As the bank has insisted for this, now he has filed an affidavit in the second affidavit saying that that he undertake that payment of first installment of rupees 1 crore and restoration of fiscal portion in his favor. In case of default from his end to pay the second installment, the fiscal portion of the scheduled property will be voluntarily delivered back to the bank. When a submission is made with the land council for the bank, and this court also insisted the petitioner to file a better affidavit, but to file an affidavit of the tenants who are in possession of the property. Land council has started arguing on the merits of the matter. He submits that a coordinate bench of this court has passed an order on
25/11.
On 25/11/2025. The order of the coordinate bench reads thus, extract the entire order. Then this matter has come up before this court. But this matter went again on 28/11 or 2025. Another order is passed with the coordinate bench of this court. Extract that order also. Then on 8/12/2025, this court has passed an order. On 10/12/2025,
May I
extract
interfere?
this order.
I'll file the necessary affidavits of the tenants, my lord.
And if there should be, just because an order is not passed in your favor, that's not the way you raise the voice and say.
I'm
make
sorry
this
for
kind
that.
of
I'm sorry
submissions
for
to the
that.
court.
I'm sorry for that.
I am the
I
last person
apologize.
to take all this, Mr. Council.
I apologize. Ma'am. I apologize. Ma'am. Kindly have it tomorrow, my
I
lord.
shall file an affidavit of the tenants. List this matter tomorrow.
Obliged. Cell number 22. Naveed Ahmed for petitioner, Satish B.
The bank has filed a statement, lots. I need to file with joint time lots. It is a prior lease note, thereafter mortgage notes. Lease was made in my favor notes on 39.
Yes.
30th.
Yeah, for the respond number 1, my lords, we had.
Can be adjourned? Are you ready with the arguments?
We are ready, my lords.
Huh?
We are ready, my lords.
Argue?
Yes, my lords. My lords, in this case, we had sanctioned a loan amount of rupees 60 lakhs to the respond number 224. They are the owners of the scheduled property. Now, the tenants have been claiming that they had entered into a lease agreement before our mortgage deed. So they are telling that we have the first charge. What I am trying to tell is we have given the loan, but then we have served 13-2 notice as well as newspaper published, and on 12/4/22 we sanctioned, but then the deed was made on 25/4/2022. We gave to 13/4 notice on 1 minute, right?
12/8/25.
12/8/25, but then they gave a reply notice after that. That is on 10/9, my lords. So only after we gave the notice of 13/4, they gave a legal notice to the respond number 224, claiming that give the refund, give back the amount of 50 lakhs which have been given as the lease amount. So what I'm trying to tell is that the owners and the tenants have collided because they didn't disclose about the lease agreement when they came into mortgage deed. So we were not aware of that. But after the tenancy was completed, the tenancy was for 3 years. It got completed on 30th/9/2024. After that, we gave the notice on this year, 12/9. Now they are coming up with a legal notice saying that give the refund after the tenancy has been done.
The interim order earlier granted with this court is extended. This is master activation.
Public notes.
23. Cell number 23.
Option is stayed. Option is stayed.
Let's see the order.
Yes.
How it is.
Please.
What is the?
And on the same day, auction is also conducted. They say. The confirmation of sale also, my lord, this honorable court has.
What do you say about this?
Sorry.
Have you seen the interim order?
Yes, we have seen the interim order. By the time the interim order was communicated to
And
us,
what about interim order communicating? What he says is, he purchased a property in the year 2019 as for an amount of rupees 40 crores.
That's correct.
For that, you have fixed what is the reserve price now?
Now the reserve price was kindly, can I persuade the court to kindly take page number 99, annexure R25?
Have you filed your objection?
Yes. Detailed objections is filed.
Let's see that.
I'll straight away take this honorable court to page number 99, annexure R25.
99, yes.
Please. This is the letter. Kindly appreciate. This is the 5th time we have put it up for auction. First time it was based on the reserve price. Subsequently, there was no bidder. We went on reducing. Those auctions notices are not challenged. At page number 99, this court will kindly see that he himself writes a letter to the bank. The translation is also filed. The translation is at page number 99, annexure R25. He himself writes to the bank requesting the bank to sell it to a particular person at the rate of 20 lakhs. He admits to the fact that the property could not have been sold for a higher price, and this is the 5th time it has come up for auction. And it was at that point in time, now kindly appreciate, he writes saying that I request you to sell it to my relative, Srimati so-and-so, for 20 lakhs, otherwise it will generate my...
Did you disclose this fact in your writ petition?
No.
No, my lord.
Why?
The thing is this, my lord. The balance amount, my lord, she will pay, my lord. This letter, my lord, under the pressure of the bank, my lord, we have written.
Is it not the
At
duty
that
of
time,
the
my lord,
petitioner?
we were not
Please
having-
understand.
Please, yes.
Let me complete my question. Is it not the responsibility? Are you not supposed to state this fact in your writ petition?
Since at the time of filing of the writ petition, my lord, we were not, my lord, given this letter.
Won't it amount to suppression of facts for getting a interim order from this court?
Since, my lord, since the party has sent, my lord, more than 8, 10
I am referring to
letters-
the party, not
Yes,
to you.
Yes, my lord.
So there is
At that time,
suppression on the
my lord,
part
you
of
are
your
not
party.
aware- Yes, my lord. At that time, my lord, I was not aware that, my lord, these letters were
Only ground,
taken, my lord.
only ground on which this court has
And
granted
this
the interim
copy also, my
order
lord,
is,
is not with the party, my lord.
you said you
Please.
purchased a property at 40 crore,
Yes,
40
I have
lakhs in the year
produced the sale deed also.
2019.
Yes,
And they're selling it for 20 lakhs.
yes, my
That's the only ground you have raised.
Yes, my lord. The reserve price, my lord, which is fixed, my lord, without obtaining the present market value, present, my lord, guideline value, my lord, they have fixed it, my lord, for 20 lakhs, my lord. That is only my contention. Regarding, my lord, the letters are concerned, my lord, the office copy also is not with me, my lord, with the parties, my lord. Since, my lord, they have written, my lord, given to the bank, my lord. They have not obtained any, my lord, office copies. That is why, my lord, I could not able to produce it, my lord. When they have served the statement of objection, that time when we inquired, my lord, he has given, my lord, 7 and 8 request letters to the bank.
What happened to the earlier several sale notices that were given by
That
the
was
bank?
not considered, my lord. My representations were not considered. And, my lords, at present, my lord, the
Did
market
you
value is
question those
more
sale
than.
notices?
Please, my lord.
Did you
Sale
question?
notice is served, and, my lord, I have challenged it before the.
No,
this one.
no. They say they have issued several sale notices before this. Have you questioned them?
My lord, the present notice, my lord, after the receipt of this, my lord, I have, my lord, filed this present writ petition. Prior that, my lord, I have requested, my lord, several given
What was the reserve price
representation.
then?
Reserve price was about 39 lakhs. Every time there was no bidder, 10% was decreased. And the paper publication, all the procedure that was prescribed under the rule was in place. It was intimated to the other side also, to the party. And it was the 5th time online auction, e-auction was conducted on the same day when the matter came up before this court.
So what is the amount that fetched now?
Sorry?
What is
We
the
have
amount?
placed that also, that material also is before this honorable court. We have communicated also. Annexure R27 at page number 102.
What is the amount?
Amount is 20 lakhs 10,000.
Sold for how much?
20 lakhs 10,000. And on the same day, kindly appreciate annexure R28 at page number 103. We have also sent it by email and as well as sent a speed post. On the very same day, at 2:45 itself, this letter is dispatched to the successful bidder. In fact, we requested that we have given an endorsement or a reply to this letter also. This court will find it at annexure R26.
Yes.
Wherein we say that, she is entitled, the person whom they designated, she is also entitled to participate in the auction. Page number 100, R26. The chronological list of events that has taken place is along with my statement of objection. This court will find from page number 1 itself.
Yes, please come.
And the, my lord, at present, my lord, the balance is, my lord, 34 lakhs, my lord, and all. Now, my lord, the petitioner, my lord, has the purchaser to purchase the property, my lord. Let them, if
How
they
can
allow,
it be? How can it be?
they allow, my lord, we can, my lord, at least, my lord, for the present market value, my lord, or present guideline value, my lord, we can sell the property. Otherwise, my lord, I have to pay the balance amount.
What were you doing from the last 6-7 occasions when the property is put
We
to
were
auction?
also, my lord, trying for
That's
the
not,
purchasers.
that is not what we decide now. Please
Thereafter,
come.
my lord, now the fixation of, my lord, the reserve price is concerned, my lord, it is very less.
The
20 lakhs, my lord, the 50%
present
of the,
petition
my
is
lord,
filed.
market value.
Questioning the following prayer. It is a specific case of the writ petitioner that petitioner has obtained has availed the loan from the respondent bank by mortgaging the scheduled property. The petitioner has requested the bank for settlement of the loans transaction, but the respondent bank has not considered the request made by the petitioner. Bank has not issued any demand notice as required under law. The bank is proceeding with the matter without following the due process. In the course of argument, when the matter came up for preliminary hearing, Land Counsel for the petitioner submitted that he has purchased a property in the year 2019 for an amount of rupees 40 lakhs and the same is put to auction at 20 lakhs reserve price by the respondent bank. Considering the said submission of the petitioner, this court has passed an interim order on 29/10/2025. Extract the interim order. The bank has filed its objections. Land counsel appearing for the bank submits that by the time the order of this court was communicated, the bank had conducted the auction and the highest bidder had paid the amount, 25% of the
25%.
25% of the amount. It is submitted that, in fact, the petitioner has given a letter to the bank, page number
100.
Has given a letter to the bank that
Sorry, the communication to the bidder is at 103, annexure R28.
is at 99.
The petitioner's letter is at 99, please.
The petitioner has
translation is
addressed
at
a letter to
99.
the bank stating that from 12 December 2024, the bank has seized the guaranteed the property and not been able to sell the same to any party. Therefore, he requested the bank to sell the property to his relative Pratima Roy for rupees 20 lakhs. Otherwise, it will generate much interest, and hence requested the bank to sell the property at the earliest. Then on 16/10/2025, bank had replied to the petitioner stating that if the bank is going to conduct the auction on 29/10/2025, if the relative is interested to purchase the same, the petition is directed to advise him to participate, advised him, her to participate in the e-auction and purchase the property as per the terms and conditions mentioned therein. Land counsel appearing for the bank submits that this is the sixth auction.
Fifth
This is the fifth auction. And the first auction, the reserve price was 13.9 lakhs. On all the
The
occasions,
distress sale value was 22,76,000. And the guidance value was given as 19,93,000.
the auction could not be conducted as no buyers has come forward. So every auction, they have reduced the value by 10%. And further, the letter that is issued by the petitioner reveals that there are no people, purchasers to buy the property. It is a submission of the land counsel for the bank that the petitioner has suppressed all these aspects, all these issues and come before the court. In response to that, land counsel for the petitioner submits that there are buyers and if the court permits, he would be able to sell the property at a better price than what the bank had sold. So that it will be of some use to the petitioner. Next, having got the counsels on either side, peruse the material on record. This court has perused the affidavit. When the submissions that were made by the bank, by the land counsel for the petitioner at the time of preliminary hearing with regard to the property being sold at 20 lakhs, which is purchased at 40 lakhs, when he is aware of all these aspects, when he has addressed a letter to the bank, nothing has been stated before the court. In fact, it is a case where the petition has come before the court with suppression on the misrepresentation of facts. A party who has come before the court with suppression and misrepresentation of the facts is not entitled for any relief from this court while exercising the jurisdiction under Article 226 of the Constitution of India. In these circumstances, this court do not find any legal grounds to interfere with to pass any order in favor of the petitioner. Accordingly dismissed. Yes, next.
Till number 24, Arjun Rao, for petitioner, Vignesh Shetty.
No, 24.
Filed the Wakalatama before the registry before the today. I filed my lord my Wakalatama before the registry today. Maybe.
Yes, what are
My lord, what has happened in this matter? The there was a principal borrower who had borrowed money from the Bank of Baroda. My lord, the principal borrower went into liquidation. A financial creditor had filed a proceeding before NCLT. My lord, that CIRP proceeding was admitted by the NCLT. NCLT passed a final order at page 109, Annexure D, approving the resolution plan. Just have one or two paragraphs of the resolution plan, page 123, 109 at 120.
This is the original borrower.
This is the original principal borrower. I am the guarantor, my lord. Please look at page 123, settlement, end of the page, para G, settlement proposed to the stakeholders in the resolution plan. The successful resolution applicant has submitted a resolution plan with a guaranteed consideration of so and so. A brief snapshot of the details of payment to various stakeholders as per the waterfall mechanism is presented below. Now your lordship sees subpara 2 is financial creditors including the bank. Then your lordship would kindly come to paragraph 126, timelines that are envisaged for payment. It is submitted 9.1. Upon approval of the resolution plan by the adjudicating authority in accordance with the code, the aforesaid manner of distribution will be binding on all stakeholders of the corporate debtor. That means including the bank. Then please look at 143. What is the effect of acceptance of the resolution plan? Please look at 143. Para 15. Insofar as the subsidiaries of the corporate debtor, part B of the resolution plan deals with the same, more particularly so and so. Please look at 3.11.6. Therefore, basis the fresh slate principle, all liabilities of the corporate debtor, if any, in its capacity of shareholder of its subsidiaries, joint ventures, so and so, so and so, and entities where corporate debtor is shareholder, shall stand extinguished, settled, abated, and written off with effect from the NCLT approval date by virtue of the order of the NCLT approving the resolution plan, and the resolution applicant or the corporate debtor shall at no point of time be directly or indirectly held responsible or liable in relation thereto. Now, my lord, this resolution plan is approved at page 156 by more than 75% of the committee of creditors. Your lordship will get it at para 25. On hearing the submissions, the learned counsel for the resolution produced the record, we find that the resolution plan has been approved with 77.55% voting share. As per the COC, the plan meets the requirement of being viable and feasible for revival of the corporate debtor, so and so. Then 28, next page, my lord. Subject to the observations made, the resolution plan is hereby approved by this adjudicating authority. Now, my lord, after the approval of this adjudicating,
Date of approval is?
8/12/22, that your lordship will get at 109.
Yes, yes.
8/12/22. Now, my lord, after this resolution plan was approved, the principal borrower made an application before DRT saying, now, as a principal borrower, is now my liability is now substituted by the resolution professional. He has to deal on behalf of the. So please delete me from the proceedings.
Let's go to that.
Please come to page 204 is the application filed by the bank, by this principal borrower. 204. Be pleased to strike out the applicant first defendant from the array of defendants in so and so. Sorry, my lord. Page 204 is the application.
Yes.
The affidavit precedes it at page 199. Just have a look at the affidavit supporting this application. Paragraph number 5 at 200. It is submitted that in the year 2021, one so and so filed an application under section 9 of IBC before NCLT Chennai to initiate corporate insolvency resolution process against the applicant company. Honorable NCLT Chennai by order dated so and so allowed the application and initiated and appointed resolution professional, etc. Then paragraph 8, paragraph 7,
No,
first respondent bank.
What you read, which paragraph?
Paragraph 5 I read. That is the approval of the admission of the application.
Yes.
Then para 7, first respondent bank filed its claim with the RP as a financial creditor, and RP has admitted the claim of the first respondent as financial creditor. First respondent became a member of the COC. Then it is submitted that during the CIRP, the resolution professional received a resolution plan for revival of the applicant with a value of 425.93 crores submitted by one so and so as prospective resolution applicant, and the same was placed before COC. Then, my lord, please come to para 10. This is the order I read out to your lordships. NCLT Chennai by order dated so and so approved the resolution plan and handed over the applicant on a clean state to the successful resolution applicant, etc. Then 14, it is submitted that the first respondent bank has already received upfront debt payment of 11.71 crores as per the approved resolution plan. The liability of the first defendant company, if any, to its creditors, including first respondent bank, stood extinguished from the date of approval of the resolution plan by the Honorable NCLT Chennai dated so and so. Then Supreme Court in so and so says so and so. Then, my lord, para 17, Supreme Court in so and so categorically held, once resolution plan is approved, all claims stand extinguished and the corporate debtor is handed over to the resolution applicant as a fresh slate. It is submitted that the applicant is now functioning under the management of the successful resolution applicant on a clean state by wiping out all prior liabilities, since the approved resolution plan provides for payment of claims of the creditors, etc. Admittedly, the first respondent bank does not have any claim against the so and so, so and so. Then 203, relief. It is prayed that this tribunal be pleased to strike out the applicant from the array of parties, etc. This order is, this application is considered at page 208. Dated 12/6/2024. This IA is filed by D1, that is the principal borrower, for deletion of his name. Learned counsel for the applicant bank submits that no relief is sought against D1.
What is that OA?
That is, the OA is at page 35. This is filed before the...
See, what is the relief they're seeking in the OA?
Yeah. Page 35, annexure B is the OA.
Let's see where are the reliefs sought.
Yeah, I'll just come to that, my lord. Your lordship would kindly see. Please look at page 40. They refer to the proceedings. In view of middle paragraph, my lord, in view of the default committed by one of the operational creditors by name so and so, initiated proceedings before NCLT Chennai and has ordered for commencement of so and so process. Then please look at the first line of page 41. Resolution plan is yet to be approved by NCLT Chennai. First sentence of page 41. Now, please look at the reliefs that have been sought. 68. They are asking for 511 crores.
Based on
Page 68.
defendant number 2.
Yeah.
2-5.
2 to
You
5.
are defendant number 1.
No, one has been let off. He is the principal borrower. I am the guarantor. Now, my question is only this.
No, but the submission is there. We are not seeking any relief. It's not incorrect.
No, it's correct only. I'll just point out.
How? Your arrayed as defendant number?
2 to 5.
2 to 5, guarantor. My lord, I'll just point out. If my senior counsel is completed.
Now, I'll just read out page 208 for a minute. Page 208. That's the order in which the application filed by the bank is allowed by the DRT.
No. If you look at 208, it says this IA filed by D1.
D1 is the principal borrower. Just come back to page 35. Come back to page 35. Your lordship sees who is D1 there.
Oh, it is allowed now in respect of D1.
Please. D1 it is allowed. Now they are only proceeding against the guarantor. Once the resolution, is it possible? See, my lord, it's just this. Just have a look at 133 of the Contract Act for a minute. Your lordships are aware of that. 133.
No, they will not seek any relief against the principal borrower, and now they'll go against the guarantor.
Whether it can be done. 133.
Yes.
Discharge of surety. My lord, I am like a guarantor or a surety. Any variance made without the surety's consent in the terms of contract between the principal debtor and the creditor discharges the surety as to the transaction subsequent to the variance. So he has agreed now to accept a lesser amount. From 511, he has now agreed to accept 425. Out of 425, he has already received 11. That means he has acted upon the resolution plan. Can he now come back to me? I am not a party to that, because my debt or my liability is coextensive with that of the principal debtor. If the principal debtor goes, I should also go. This is a matter that requires consideration, is all I am saying, my lord. Your lordship may
kindly come to my lord, annexure B, page number 35.
Annexure
B, page number 35.
31.
35.
Hmm.
I filed a original application.
Hmm.
My lord, defendant number 1 is Sika Logistics, wherein my lord, my senior counsel made a submission before this honorable court that resolution plan came. 2 to 5.
The guarantors.
Guarantor. My lord, kindly come to my lord, the petition which we filed, my lord, page number 57, 21. How they arrayed as a party. Paragraph number 21.
57.
Page number 57, in that, my lord, paragraph number 21 of my original application.
Hmm.
The applicant bank further submits that the first defendant and the said late Mr. Siddhartha, he is the, my lord, principal, my lord, executed a guarantee.
Siddhartha is the original guarantor who died, his LRs are.
Guarantor. The facility sanctioned to the first defendant company subsequently 131/7/2019. The said Mr. Siddhartha died, leaving behind defendants 2 to 5 being his wife and 2 sons and mother to inherit his estate. As such, them being the legal heirs of the deceased guarantor are liable to be extent of the estate they were inherited from him. Accordingly, they are arrayed as a party or a party defendants in the above original. Kindly come to the prayer which I sought.
I know that.
Before the Milord,
Sure,
Recovery Tribunal. Milord, page number 69, 68, Milord. The first prayer, directing the defendant number 2 to 5 to pay the applicant bank sum of rupees 387 crore and subsequently 1.26 crore, etc. Milord, next pages, Milord, from page number 71, there are certain properties which Milord given by the Milord mortgage property to me, given Milord offered by Milord the guarantors. Milord, I have to take a complete instructions on that. Guarantors, which is succeeded by the Milord legal heirs.
No.
No, Milord, in
Before
respect.
going into that, what is the significance of that proceedings before the NCLT?
Please, my lord. Resolution plan came.
In respect of the principal borrower.
Please, my lord.
And in view of the settlement or in view of the
Not
scheme
settlement,
between whatever it is
Please, my resolution plan.
that is arrived at,
Is IBC
what is
now.
what is the binding force of that on
My lord,
these proceedings?
I am not entitled to proceed against the principal borrower. The reason is, my lord, resolution plan submitted only against a corporate debtor in respect of, my lord, defendant number 1. Therefore, my lord, I am obligated, or my lord, in fact, on that effect, my lord, I filed a memo before the court, my lord, before the DRT. I am not proceeding further. In respect of the guarantor,
It's an independent liability.
it is an independent liability against a guarantor. My lord, yes, still, my lord, my debt is in existence. I have all the rights to proceed against a guarantor. There are certain, my lord, properties which is inherited from their deceased, my lord, guarantor.
So the settlement
Apart
is
from that.
settlement is for what?
Settlement, my lord, I'll just put it in this way, my lord. Either section 7 or 10 or whatever, my lord, applications which we filed before the NCLT. Where, my lord, the petition will get admitted under section 7 or 10. I have to find out whether what is the petition here. Resolution plan came by the, my lord, that is in respect of only corporate debtor, not against, my lord, other guarantors. Which against a guarantor, no, so, my lord, the position of law is very clear. I am entitled to, my lord, proceed further. Even, my lord, even though, for example, section 7 got admitted, I am entitled to file section 95 against, my lord, corporate guarantors. Personal guarantors under section 95. That, my lord, IBC section 95, my lord.
Take it.
IBC.
Lord,
Insolvency and
may I
bankruptcy
just
code.
point out, I think the mistake that has happened is, please look at 91. That is a part of the OA. When was it filed? It was filed before the resolution plan was, because that is why at page 41, he says,
Now the
resolution plan not yet accepted.
now the legal issue, that's only a legal
Can
issue
you
that's
proceed
involved.
against the debt?
That's
CDs or
My lord, insolvency and bankruptcy code section 95. Even though, my lord, the companies got, my lord, liquidated or, my lord, resolution plan came, I am entitled to file, my lord, file an application under section 95 against a guarantor. It is settled position. I don't think so. My learned senior counsel will deny on that aspect.
That's what is the submission is that he cannot.
I don't.
No, I am on 133. Once you have accepted the settlement with them, you can't proceed against me for the balance.
But apart from that, section 95, just read the section 95 my lord, for a moment.
Only that issue you clarify, Sapafa. No further clarification is required.
Section 95 of IBC. Insolvency and bankruptcy code. Do you have copy?
I have,
I'll just read.
can I give your lordships?
Yes.
95, could you?
In fact, that aspect, my lord, clarified by the Honorable Apex Court in the case of my lord Lalit Kumar Jain versus Union of India.
Let's have the judgment.
I have one small note, Mason. I have one small note on that effect. I am so sorry.
Citation, you know?
Lalita Kumari versus just Union of India.
Right.
It's in 15 cities. The judgment. I have.
See which is the citation.
Citation.
Hmm?
Citation.
2019, I know, yeah.
Challenge to 2019 notification. Update is of 2021.
Does your lordship have the citation there, my lord? I'll just, because
It's not, it's a kind of a note on that.
it's a note on it, the citation illa illi.
Lalit Kumar Jain versus Union of India. That notification.
Now, what the conclusion as per what he concluded is, the judgment provides much needed clarity on initiation, continuation of insolvency resolution process against personal guarantors. It also provides clarity that the release or discharge of a principal borrower from the debt owned by its creditor due to liquidation or insolvency does not absolve the guarantor of his or her liability.
Please,
That is insolvency proceeding.
Here also, my lord, IBC proceedings, my lord, pursuant to that, my lord,
This is not
insolvency. Insolvency and bankruptcy.
This is filed under which section?
IBC code only. IBC
Section
code.
95.
No, this is DRT proceeding,
No,
page
now
35.
You were referring to the NCLT.
Yes, yes, yes. IBC code.
That's what
IBC.
it is.
I'll examine, my lord, your
Please
lordship.
examine.
I'll examine.
Yes.
Apart from that, my lord, my respectful submission.
Lord, let him
So
file
anyway,
his.
I'm not granting any interim order.
I bowed down.
Yes.
So just have a look at section 31 of the code, my lord, in the same thing. Cyber code, one nimsha.
We will have we'll hear it at
The
this
31 says it's binding on everybody, my lord. That's why. The resolution plan,
A judgment you need to see how it is interpreted by the Supreme Court, this side of the vacation or after vacation. Unless I'm convinced on that, I can't grant an interim order.
my lord, it's posted on the reopening day. That's why I'm requesting your lordship, just
I'll hear
let
this side of the
status quo be
vacation.
maintained till then, my lord. Otherwise,
Unless I understand, I'm convinced with the legal portion, I
but
can't grant an interim.
this is not considered 133 of the Contract Act, my lord. Your lord, 133.
We'll see the Supreme Court judgment. Let me have the benefit of looking
Please.
at the judgment. When do you want?
Any day that is convenient to your lordships, my lord.
Yes, day after.
Grateful, deeply.
The lordship may have it after vacation, my lord.
After vacation.
Immediately after.
Senior, my lord, senior.
May I just request your lordships, not an interim order, not to precipitate your lordship may say if they come to attach your
As a
lordship may
ma-
say.
If I have to, my procedure in this court is if I have to
I know,
pass
I
an
understand.
interim order, I will record the reasons. Without recording the reasons, I will not say that status quo. That's why I'm saying, if I'll give you an opportunity with this side of the vacation, if you can convince the court, I'll take it up.
Lord,
But
they're just
not
two,
without,
my lord, in similar matters, my lord, this court, and there are two other matters pending, my lord, my friend is appearing. Just have a look at it, my lord.
Give that.
Detailed interim orders have been passed by this court. Just have a look
Please
at it.
give that.
My lord, just have a look at this order in 5456 of 25.
No.
Just have a look at
Whatever your submissions are that are recorded in this order dated 24 to 2025.
Yes,
And the reasons for granting,
it's there. After considering everything and section 31 of the IBC, they say there shall be an interim order of stay of the impugned order and all further proceedings before DRT till the next date of hearing. Then there three matters are there, my lord, just similarly like this. All matters.
but without recording the reasons, I can't grant an interim. Yes, after vacation.
Great.
Yes, 26.
Would your lordship have it on 6th or 7th, my lord, because the matter is on
7th.
9th before 7th.
Then number 25, Ramesh T. Appealing to the petitioner in this matter. I've complied all the office objection only with regard to Annexure B. We don't, that's the only copy we have, my lord. I may be allowed to make the submission on the interim relief.
Which
What
is
has
the
happened,
bank?
there are two possession notices which has been stick to my property, which is the petitioner's property, and I have not taken the loan from those
Who
particular
appears
banks.
Indian Overseas Bank?
What is
Who's your
happening?
counsel?
That is M.R. Shashidhara, M.K. Shivaram, and Keshava Bhatt S.N. Vivek S.
Mr. Keshav Bhatt is directed to take notice on behalf of.
My lord, I may allowed to make the submission.
I will not, without hearing the bank, I can't pass any orders. You serve them.
Interim relief may be given because I have not taken loan from them. The petitioner.
Hear it tomorrow.
Okay.
The petitions are the papers on so and so. I think the Divya Purandari, that she doesn't appear in this.
Indian Overseas Bank is not there now. No.
So Keshav Bhatt, Keshav Bhatt.
Yes, SN.
So SN Keshav Bhatt, so papers on him this tomorrow. Land council shall get instructions. The 27.
Serial number 27. 26.
And office objections shall be complied.
Serial number
Your Lordship,
26.
in this case, I am filing affidavit, Your Lordship, with 13 lakh yesterday matter, Your Lordship. That is 50 lakh, 50% of the amount within 4 weeks, Your Lordship. Within 6 months, I will close. I'll. If at all the bank is ready for regularize, I'll regularize. Otherwise, Your Lordship, within 6 months, I will close the matter. Because, Your Lordship, my husband has died.
The
So
loan
that's the
facility of 13 of them. I have not repaid the EMI.
the fourth para, Your Lordship.
The writ petition is filed. Questioning the
Annexure C, Your Lordship.
questioning the what is that notice issued
Annexure,
under which
the vacating
provision?
notice, 7 days notice, the vacate to the premises.
Under 13(4).
Under 13(4). Afterwards, what happened, Your Lordship, they will take a section 14 order. So after taking section 14 order,
Submitted that the petition is agreed with a notice dated 5/11/2025, whereby the petition is directed to vacate the premises within 7 days. It is submitted that it is a residential premises. And further, in fact, the petition is ready to pay the entire amount an undertaking affidavit is filed before the court that the petitioner will pay 50% of the loan amount within 4 weeks. And according to them, what is outstanding as on today?
13,70,000.
17 or 70?
70.
13,70,000 is outstanding amount. He'll pay 50% of the amount within 4 weeks from today. That means how much? 6 lakhs?
6,80,000. 6 lakhs.
He'll pay 6,80,000 by, what is today? Hmm? He'll pay by January 16th, an amount of rupees 6,80,000. And he will regularize the loan account or else clear the entire amount within 6 months. Lest this matter, there shall be stay of all further proceedings on the condition that the petitioner shall deposit an amount of rupees 6,80,000 by January 16th. By January 16th, list this matter on 17th. On that day, by that day, if the amount is not, then what is the next day? January 19th. By that time, if the amount is not deposited as undertaken before this court, the writ shall be dismissed on that ground with exemplary cost of rupees 1 lakh.
Cell number 27.
Notice to the respondent.
Cell number 27.
Madam, I'm appearing for the petitioner. There are few office objections, my lord, with regard the non-granting of.
What is your submission, counsel submission for that?
My lord, I'm not a party to the suit.
Copy of the MC petition to be filed. Objection on main MC petition. What have you questioned?
The order which is affecting me.
What is that order?
My lord, may come to Annexure A. Page number 17.
17?
17, my lord.
Hmm.
My lord, may see the cause title for once.
No, yes. Come
Cause-
to the order. What is the operative portion of the order?
My lord, page number 33. At the bottom, my lord.
To the
I-
cybercrime police in Shimoga to retrieve and preserve data, including call logs, CDR, IPDR, and memory card data for the following mobile numbers.
2 of these mobile numbers are mine. I am not a party to the proceedings.
Who are you then?
I am a third party. If I may be given 2 minutes.
If the court has passed an order, what is the relationship
I'll tell you,
between
my
you
lord.
and the?
My lord, may the 2 respondents in this petition are the petitioner and respondent in the family court in Shimoga. The respondent number 1 has leveled an allegation against respondent number 2 and me, saying that we are having an illicit relationship. Based on that, my lord, they have filed an application.
The petitioner before this court as
My
a
lord, may I
third
make
party.
one submission? The application that is filed by them is covered squarely, my lord, by Annexure C.
Granting you interim order.
Right.
The petitioner is a third party. The order that is impugned before this court dated 6th December 2025, passed in I number 4 in MC number 111 of 2025 is the court had issued a direction to the cybercrime police to retrieve and preserve data including call logs, CDR, IPDR, and memory card data for the mobile number 8727081100, 9380741203, 8660981037, 94811222105, and 748375147, which is your number.
My lord, the last 2.
Last 2.
Yes.
It is submitted that the petitioner's phone numbers are 94811222105 and 7483751457. Then counsel submits that he is not a party to the proceedings. And on the request made by the wife or husband?
Wife, my lord.
Made by the wife. The court has passed the order. It violates the petitioner's petitioner's right to privacy. And in that manner, the court ought not to have directed the police in a matrimonial proceedings between the petitioner, between the respondent number,
1 and respondent number 2.
respondent number 1 and 2. Respondent number 1 and 2. The, considering the fact that the petitioner is not a party to the proceedings. And the proceedings, and as submitted by the counsel of the petitioner, it violates the petitioner's right to privacy. There shall be stay of all further proceedings as far as 9(3), as far as
My lord,
the four numbers.
may the operative part of the order against me be stayed.
That's what I'll refer the numbers.
Yes.
There shall be stay of all further proceedings pursuant to the order dated so and so. As far as the phone number 94811222105 and 7483751457 are concerned. Notice to the respondents, but in addition, petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect.
Till number
My lord,
28.
may hand summons be permitted? I'm given to believe the matter is next on 18th.
The order will be uploaded, it's an interim order.
Obliged.
The petitioner shall file the memo to the effect that he has served the hand summons. What is the date? 12th is? By 12/1, or else on that ground, the stay granted by this court stands vacated. Yes,
Till number 28. Abhilash Raj.
and the office objections are overruled as the petitioner is not a party to the proceedings. Yes, 28.
Till number 28.
My lords, I appear for the petitioner. My lords, I'm aggrieved by the order of the family court, by way of which on 24/11, the family court expressly directs the respondent not to leave the jurisdiction.
Where is the order first?
My lords, I'm aggrieved by the order is, my lords would find that page number 23 and at page number 25 onwards, if I'm permitted to read it,
You are the father or the mother?
I am for the father. My lords, the interim,
Who filed the petition, GNWC?
the father has filed the GNWC petition, my lords. The father filed the GNWC petition. The mother had custody of the child. In the interregnum, the mother had always had the intention of leaving the jurisdiction of Bangalore, leaving the jurisdiction of India rather. My lords, in the meanwhile, we filed an application seeking a direction for them to be restricted to the jurisdiction of Bangalore. The Honorable Family Court passed an order dated 24/11 or 2025, by way of which the court directed them to not leave the jurisdiction of.
Where is that order?
My lords would find that at page number 45.
45.
Page number 45. Operative portion, my lords, if I could read it out loud. IA number 2 filed by the petitioner under section 7 and section 25 of the Guardians and Wards Act, read with section 151, is disposed of by restraining the respondent from taking the child outside the country during the pendency of the present petition without express permission of this court. My lords, the matter was then adjourned to 13/1 for further proceedings. They advanced the matter on.
You get that she shall not leave. Page number?
My lords, in page number 45, disposed of by
Outside the country.
Child outside the country during the pendency of the present
So it's
petition.
outside the country.
Please, outside the country. As the matter stands, my lords, the matter was adjourned to 13/1 for continuation of further proceedings in the matter. They advanced the matter on 9th of December and file an application IA number 6 seeking a direction.
Where is that?
My lords should find that IA at page number 77, my lords. Oh, my lords, my apologies. Page number 69.
Yes.
They file an application, advance the matter and file an application stating that they have applied for a US visa for the child.
So this is ordered.
This, my lords, 24/11, there is a direction not to take the child outside. Please.
What happened after this application is filed?
They file an application. We seek time to file objections to this. The matter is then taken up on the 12th. That is the Friday. That order, my lords, would find at page number 24. My lords, on the said date, we also file another application seeking a direction of the Honorable Court to deposit the passport before the family court. My lords,
No.
yes.
Then what is the order? The case is advanced on application.
Please.
To
This is
obtain
the order
complete
on 9.
formality for issuance of visa, tourist visa.
Please.
As filed and to direct respondent to deposit for objection hearing By 12/12.
Please.
Then?
Then on 12/12, we seek for additional time to file objections because the respondent was not in town on the very set date, my lords. The matter is taken up. There is misrepresentation on fact of the respondent to the extent that they state that the application for US.
We'll read this order.
Please, my lords.
We'll read this order.
Please, my lords, if I could. Counsel for both sides present. Counsel for respondent has filed memo with documents. He brings to my notice that appointment for taking biometrics of the minor child is fixed in US Visa Application Center, Mumbai on 14/12/2025. He submits that there is already an order passed by this court restraining the respondent from taking the child abroad and take the child to the US, but US visa was applied long back. And by coincidence, the appointment is fixed to 14/12/2025. All of a sudden, and brings to my notice that in case this appointment is missed, it may be very difficult for the child to get a US visa in the future, and therefore prays to grant permission to the respondent to produce the child before US visa center without the father. His counsel for the petitioner has serious objections to the application and seeks reasonable time to file objections. However, considering the submission that visa was applied.
When is the date for the
14/12, my lords, was the biometrics, which was Sunday. The visa interview is on 22nd. My lords should only notice, if I could draw this honorable
That's
court.
why, please take notice on the counsel for the.
My lords, before my lords, if I may kindly take this honorable court attention to page number 74. 74 is the application that they have made before the US visa consulate. The application itself is on 3rd of December. The order passed by the Honorable Family Court is 24/11, restraining them from taking the child abroad. They fill the application on.
Pass final orders on this.
Very well.
The petition is permitted to take out hand summons on the counsel appearing with the respondent. List this matter. If the memo is filed, list this matter on Friday.
Grateful.
Get the matter on Friday. And if not, if there, you have to file the memo for that.
Grateful, my lords.
Cell number 29, DJ Sungapur.
For appellant matter, the respondent number 3 filed the application for recall of the order dated 17/4/2025.
And in this case, my lord, these matter which was Lordship has passed the order belongs to Dharwad bench. We have requested the Assam court to transfer that matter to Dharwad bench. But anyhow, company is liable to pay. You can settle the matter. We have addressed the argument. Later on, we came to know that manner. Dharwad bench, the company has filed the appeal and they have settled the matter, compromised the matter, and they have taken the amount.
How can it be done?
They have not brought to our
What
knowledge.
happened, my lord? They are passengers, my lord. These claimants belongs to the jurisdiction of the MACT Davangere. They are belongs to the MACT of, they are going to the Tirupati, my lord.
What he is saying is, very same petitioner.
No, my lord, no,
Or the
not-
appellants.
No, no, my
have
lord.
already settled the claim and taken the money.
Not the same appellants, my lord. They are the other claimants.
I mean, permitted to.
Let him say. You have given a copy of it to him?
No, your BC Sitaram has filed the application. We have placed the records to him.
Yes.
Lord, kindly peruse the,
Who has filed the IA?
I have filed by the respondent number 3.
The mark you then. Yes.
But in this case, with the BC Sitaram has filed the on behalf of them.
You are representing him?
No.
Then where
I
is
am
he?
representing another company, insurance
Then
company.
where is he? Yes, this is matter after vacation.
My lord, kindly peruse the charge sheet, my lord.
There are.
The person who has filed the IA should be there.
On the last
As
occasion-
long as that order is in force, unless the order is recalled, earlier order is in force or not?
Yes, my lord.
That is to
On
your
the last
advantage.
occasion also, they is not represented, my
No
lord.
representation on the last 2 occasions. This is matter after vacation. If there is no representation on that day, the IA will be dismissed on the ground. Yes, next.
Date kindly be fixed, my lord.
We can't indicate the date now. Yes.
Number 30. 30, BC Shivanegowda.
Insurance company appeal on the ground of liability, old policy, earlier policy. Charge sheet was filed on 181 of the motor vehicle. Owner has appeared, he has not placed the driving
No,
license.
when is the policy? Date of the policy?
Prior to the amendment. Pay and recovery order only.
So if that's the only order. So
That
what
is the only
amount?
order we,
What is the amount?
1,15,774.
15,000?
1,15,007. I'm ready to deposit the entire amount. Let them withdraw 50% of the award amount.
The land counsel for the insurance company submits that there was no, it is a case of no permit
No deal.
deal. It is
180.
submitted that the driver of the offending vehicle is not having a driving license in spite of the same. The court has fixed a liability on the insurance company. The court ought to have passed an order of pay and recover. Considering the same, there shall be stay of all further proceedings on the condition that the respondent shall deposit the entire amount. On such deposit, the respondents are at liberty to withdraw 50% of the amount. Notice to the respondent. Yes, Hariba.
Match.
4 weeks, that's common on.
Insurance company appeal limitation barred by time. Policy issued on 4/10/2023. Date of accident 14/12/2023.
After
1/4/2022 after amendment 1/4/2022.
No. The accident happened when and when the claim petition is filed.
Claim petition date of accident 14/12/2023. Claim petition filed on they have filed on claim petition for lapse of 6 months, my lord.
Land counsel for the applied insurance company submits that from the date of accident, there is a delay of six months in filing the claim petition, and it is barred by limitation. Considering the submission, there shall be stay 50% 4 weeks notice. Yes.
32, my lord. Insurance company challenging on the road quantum, my lord.
How much is the amount granted?
Awarded, my lord. 5 lakh rupees awarded, my lord.
5 lakh?
5 lakh.
What is disputed?
Disputed up to we will deposit 2 lakh rupees, my lord.
It is submitted that the insurance company is on the question of liability. Considering the submission, stay 50% to be deposited, and the respondent is at liberty to withdraw 40% of the amount.
Number 33.
Notice to the respondents. 33.
Appellant in this case, insurance appeal challenging liability, my lord. Insured was appending vehicle tractor. The insured was purchased from tractor for agriculture purpose, but at the time of accident, he was
Case of death or injury.
Injury, my lordship. He was fitted.
That you are on the quantum or on liability?
Liability, my lord.
Because why you are not liable?
They were pitted for borewell lifting mission without permission to RTO, my lordship.
They submitted that the insurance company is the question of liability, as they have attached
borewell lifting mission. Borewell lifting mission.
Borewell lifting machine to the tractor, and as such, there is violation of terms and conditions of the policy. Insurance company is not liable to pay 50%. There no permission to withdraw 4 weeks. Notice to the respondent. I-125 is not pressed. The same is dismissed as not pressed. Yes, next. 34.
Cell number 24.
34.
34.
Notice to the respondent.
Cell number 35.
Yes.
125 proceedings, my lord. A maintenance of 20,000 is awarded, my lord. The only submission
Is there
is,
any
my lord,
interim order?
No interim. No interim. My lord, I was placed expert. In fact, my lord, I could not
How much is the
cross-examine
amount
Peter.
granted? 1 minute. How much is the amount granted?
20,000, my lord. My salary is 26,000, my lord.
Only wife or wife and children or also?
No, only wife. No issues, my lord. Kindly say my
So
salary
salary is
certificate.
21,000. 21,000. Salary
Salary is 26,000, my lord.
26,000. How
Page
much is
27,
awarded?
my lord.
How much is awarded?
Awarded is 20,000, my lord.
Yes, we'll hear it.
Please, my lord.
We'll ask him to, if it is 26, we'll ask him to deposit around 10,000.
No, it's not placed ex parte. In fact, he has contested, he has filed this up.
It is ultimately we have to hear the RPS, is it not? If he doesn't pay any amount, it is good for your client that she'll get some amount, and eventually we'll hear this matter.
Interim
They will
maintenance
submit-
was granted 7,500, my lord, by this court, my lord.
You said no interim order.
No, at the time they passed 10,000 rupees as interim maintenance was.
The
This court granted
petitioner,
7,500.
It is submitted that the petitioner salary is 26,000 and the court had granted an amount of rupees 20,000 as maintenance, and which the petition is not in a position to pay, considering the same stay on condition of paying 10,000, and the arrears also at 10,000 within 12 weeks. Mr. In 35.1, Mr. V. Anand is directed to take notice on behalf of the respondents.
Stay,
Yes.
my lord.
This is matter in the month of February.
Stay, my lord, because they have taken 120. my lord.
On that condition, 10,000 by 5th of every succeeding month, arrears also at the same.
Please, my lord.
Within 12 weeks. Yes,
petition-
sir.
Bharat Kumar S.
Well, there's two IS, man. One is condonation of delay and the other one is first time, my lords.
869 days delay.
My lords, initially this honorable court had stayed the matter, my lords, but in the writ petition, the two prayers, my lords. One was the final order and the perjury applications. So this honorable court directed to file a separate petition, my lords. So on that day, on 10th July, the stay order was vacated, my lords. My lords, in this case, I have not driven the respondent out of my house, my lords. She has voluntarily gone, and I have booked her air tickets, and in a place.
You
all
file
those-
your objections to the IA. Yeah, have you filed?
I've served a copy on the very same day when the matter
Served
was
the
listed.
copy, but I have no instruction for this case, your lordship, because it is connected to another case which is pending, your lordship, second item. 204/23. 204/23, I have for enhancement of the final order. my
No,
lord.
we will not hear the enhancement case now. The petitioner shall serve the copy of the.
I already served, my lords.
You have served?
Copy has been
Petitioner,
received.
If the respondent, if objections, if any, shall be filed by the next date of hearing. List this matter after.
My lords, one submission, my lords have been paying the maintenance what is ordered by this court, my lords. They have filed one recovery in Udupi, my lords. I requested that honorable court to give a date for tomorrow, but still they have issued a warrant, my lords. I've been paying maintenance every month, my lords.
Can I make one submission, my lord? In such case, can I make one submission? Yes, till more than 3 lakhs is due is there, not paid. Hence, your lordship, new interest.
This matter is coming up for the first time. Which
Yes.
court has directed? I'm not able to
My
understand.
lords, when the matter was stayed,
Where is it stayed?
my lords, my submission is where the matter was stayed by this honorable court, my lords. At that time,
Which proceedings?
In the writ.
WP 24603.
How that has a bearing on this?
No, my submission, my lords, because
As your lordship
when the
vacated.
Wait,
It
let
has
him
been
argue.
vacated.
when the matter was stayed, my lords, initially the trial court ordered for 22,000 rupees, my lords. When the matter was stayed, this court ordered to pay 12,000 rupees per month. So the difference amount which I have not paid, they have filed for recovery, my lords.
So,
I've been paying there also, my lords.
No.
The court is not granting me time, my lords. For that
More
reason,
than 3 lakhs
my-
due. More than 3 lakhs is due as on date.
after 869 days, I will not grant
Yes,
stay like.
yes,
that.
my lord.
My
I have
lords.
serious objection.
Yes.
And second
Notice
matter, my
to
lord,
respondent.
one submission. In second matter, only 24 days delay may be conducted. Because so
I
far
will
they have
condone
not, one
this now.
submission.
We will see.
I
that.
will make one submission,
Mr.
only one
Venkatram-
word, my lord.
Venkatramana MK is directed to take notice on behalf of the respondents in RPFC 326 of 2025. Both the matters will be heard after vacation. List this matters after vacation.
No, in another matter, they have not filed the wakalat. Your lordship kindly says in second matter, even though served.
Notice is served.
Huh?
Notice is served. If they
Yes.
don't file the wakalat, it is their problem.
No,
We
they
will
have not
hear it after
filed. So far,
vacation.
they have not filed in the second case.
I undertake to file.
No, no, undertaking what, when it is, delay
Yes,
may be
after
condoned.
vacation,
In
this
such
is
case,
matter.
delay of 24 days may be condoned in
Yes,
204/23.
Vishnu Sharma,
38, yes.
37.
Lords, I appear for the petitioner, my lords. Husband, my lords, is before this court. Lords, ex parte order, my lords, of 8,000 to the wife and 4,000 to the child. Lords, I was not served, my lords, with the notice, my lord, before the trial court. Lords, that is why, my lords, there is also delay of 176
How
days.
much is granted?
Lords, 8,000, my lords, to the wife and 4,000, my lords, to the child. Lords,
Up to 12,000.
12,000.
What is your salary?
My lords, my salary, my lords, I'm not employed. My lords, I'm not employed. I'm a plumber, my lords, in Mudigeri, lords, village. Lords, if I get work, my lords, I have work. Otherwise, I don't get paid, my lords, as such. Lords, my lords,
What is that you are going to pay? Basing on that, there will be interim order.
please, my lords, may fix it, my lords. Half of that, my lords, I'll pay, my lords, including the arrears, whatever it is.
It is submitted with the land council that the notice is not served. As such, you could not contest the petition. He is working as a plumber in a remote village. The court has granted 12,000 maintenance, that is 8,000 to the wife and 4,000 to the child. And it's difficult for the petitioner to pay the same, considering the same 6,000 and arrears also 6,000 within 12 weeks.
Please, grateful.
Notice to the respondent.
Till number 38.
Lords, now she has, my lords, filed the, my lords, execution
They shall be
proceeding.
stay on all further proceeding.
39.
38.
38 is
38.
Let's,
Morning, there's a-
petitioner is passed,
The tie-up for extension of time.
let's in this case, petitioner is passed, I am reporting the death of the petitioner.
That's what I have recorded it, the death of the. What is it, the memo? Take that memo also.
just
Petitioner
reporting.
has filed a memo. Already morning order is passed, but still the memo is taken on record stating that the petitioner is no more. As a petition has become infructuous.
That matter is already disposed of.
That I understand. Take this memo. That is on the submission of the respondent counsel. Petitioner has come, no, take it. Yes.
Cell number 39. But Veena Venkataramana.
Your Honor, last date of hearing, I filed the affidavit. In that, the court has told to file the statement of accounts. So the bank has filed the statement of account of 68 lakhs, 72,282. In that, 31 lakhs are already paid, Your Honor. They have told last time they have agreed for the 31 lakhs. Balance 37 lakhs, 72,000 within 3 months I'll pay, Your Honor.
I have not agreed for anything, Mona. This, in fact, my lords, the affidavit may kindly be taken into. In the affidavit, their calculation is that I have taken 60 lakhs loan. Since last 7 years, I have paid 30 lakhs. So only I have to pay 30 lakhs. No interest, nothing should come. In fact,
Honor,
this affidavit was disputed by me.
Lakhs is the pending today. Till today's 68 lakhs is the pending. In that, I have calculated that.
Who told you that 68 lakhs?
Bank
is
only
pending?
itself.
When? Where?
Last date of hearing, and they have given the
That's
statement of
there.
account.
68 lakhs. That's what. Now the 68 lakhs, what there is, I told as on that day. Now they are assuming.
Okay. From 2/12/2025, today it will become another 5 lakhs.
No. The last date of hearing itself, as submitted. In fact, this court told to produce statement. Statement is also placed on record.
Their own statement, I am telling you.
68 lakhs 73,000 rupees was as on the day of 2/12/2025. The due was
Whatever, if
68.
any amount till the time of payment, whatever it is, that you can indicate and they'll pay in the last installment. That's not an issue.
Lords, now they are telling they'll pay only 30 lakhs.
No, Your Honor, that I'm telling 37 lakhs, whatever the balance amount, 31 lakhs I've already paid.
Where is the affidavit?
Last date of hearing I have filed in the. Within 3 months, I'll make the payment, Your Honor.
Yes, fixing the quantum as per their own whims and fancies. Lords. What
No,
I-
Your Honor, as per their own
Please
thing, I'm
wait.
paying.
You cannot say. When was this memo given to you?
Last date,
Last
sir,
date of hearing.
2/12.
So you should have get instructions from your bank and you can submit. This is the amount instead of saying that they're doing it as per their whims and
Kindly come to order
fancies.
dated 2/12/2025.
I've seen that order.
Yeah, on that day, they filed affidavit. We disputed telling that this is a due. They told that they'll pay only, they kindly come into their affidavit, look into their affidavit. In their affidavit, they state they'll pay only 31 lakhs, para 2.
No, Your Honor, 31
Para
lakhs I've
two.
already paid.
If both the advocates want to argue, I'll not hear the matter, I'll adjourn it. Yes,
Kindly come to affidavit, my lords.
yes, read.
Para 2, I state that I have borrowed 60 lakhs. And in this, I have already paid 23 lakhs. And yesterday, I have deposited 8 lakhs. In total sum of 31 lakhs. This is from the date of sanction till date. What they have mentioned in their affidavit.
Not sanctioned,
This
Your
court,
Honor.
let me, madam, please let me complete. In fact, this court, after hearing both the arguments, my lords, last date of hearing, this court directed, as per the submissions of the learned counsel for the respondent, the total outstanding amount as on today after deducting all the deposits is 68 lakhs 73,000 rupees. Let the respondent bank shall file a statement of accounts in this regard. I have placed that statement of accounts before your lordships. Copy is also served on them. It's on the record, my lords. In statement of objections, the loan dues is exactly what I mentioned on that day. That is 68 lakhs 73,000 rupees.
Please come. An affidavit is
Your
filed stating
Your
that.
Honor, statement. The 31 lakhs is paid after the stay has taken, Your Honor, not from the sanction of the loan. The 31 lakhs is paid after
Court
I
is
have
not
taken the stay.
concerned with all this. Whatever the bank says is outstanding, that you're ready to pay, will pass an order. If not, you want to agitate on any
37
other
lakhs is
issues.
the pending, I'm agreed for that, Your Honor.
What you agree will not be the order. What is outstanding is what is this is already an order on 2/12/2025. Before you, this order is passed, that it is outstanding is 68 lakhs 73,000.
But they have not taken my payment, Your Honor, in this. They have, last date of hearing, they agreed that 31 lakhs.
This is matter after vacation. Yes, next.
Cell number 40.
Lords, for the petitioner, my lords, kindly requesting for passover, my lords. Senior counsel,
Is
no,
possible.
senior counsel is engaged actually.
I understand. I have a full bench in the afternoon. I won't be sitting.
My lords, he's busy in another court in the second of, by 2:30, my lords, may be taken.
Special courts, special bench.
Lords, he's busy in another court, that's why.
Your Lordship, in this matter, I am the auction
No.
purchaser.
Why, what to even respond to this? Yes, let's this matter. Next week, I mean, after vacation, 41.
Lordship, in this matter, they kindly fix the date because
January 12th is what date? Yes, 41.
Cell number 41. Kumar SJ.
But I have not challenged the any DRT order, my lord. My oversight matter has been listed before the Honorable Court, Maharashtra. I filed the petition on.
What is the prayer that is sought in this?
A writ of mandamus, my lordship.
Hmm.
Writ of mandamus, my lordship.
Then also it will come before this court only.
But I have not challenged the DRT, any DRT
Not
order.
necessary. Anyway, the bank is the respondent.
Yes, my lord.
What is that you want?
My lord, the second, respondent number 2 and 3 already housing loan from the first respondent. my lord.
Consider the representation made by the petitioner as per the reply legal notice.
Yes, my lordship.
To return all the original documents of title received by it from the second respondent.
Yes, my lord. Petition has
Which
paid
is
the
who
entire
appears for
loan
the
amount.
respondent?
My lords, I appear for the respondent bank, my lords.
Yes, what do you say?
My lords, they have filed an application, my lords, seeking consideration of their OTS, IA 1 of 25, where we have no objection, my lords. Within 2 weeks, we'll consider their OTS proposal and we'll submit our reply, my lords.
We'll dispose it of.
The second,
The second prayer, what is the second prayer? I'm not able to understand.
no, my lord, second respondent has filed the application, my lord. I'm not the borrower.
IA 1 of 25
I
is
have
filed by the
purchased
borrower, my lords.
And who are you?
I have purchased the house property, my lord. As per the instruction of the bank, I have cleared the housing loan. Thereafter, they have instruction, kindly peruse the ink page number 50, my lord.
Where is
They
the
have given
OTS
invoice,
scheme?
but they are not given
Have you
the.
have you seen the relief he is seeking?
My lords, I have objections to his writ petition, but in the meanwhile, one application has been filed by the borrower to consider the OTS. If his OTS is considered, my lord, then this writ petition will become infructuous. So therefore, your lordships may allow the application and keep the writ petition.
He's
My
an
lords?
auction purchaser. He's an auction
He's not an
purchaser.
auction purchaser, my lords. He, on his own, he has purchased the property during the pendency of the loans, my lords.
As per the
Directly, he has
instruction
dealt
of the
with the
owner
borrower.
of the
He has
bank, I
no
have
right.
purchased the property, my lord. Thereafter, I have cleared the housing loan, my lord.
Without
Thereafter,
NOC
they have
from
given
the bank,
NOC.
he has
It
directly
is the
purchased the
annexure D, my
property.
lord. Kindly peruse the annexure
A
D.
property which is mortgaged to the bank,
Yes, my lord.
you will purchase from the original borrower.
Yes,
And
my
you
lord.
file a writ petition before the court to consider your representation,
No,
to
ma'am.
return all the original documents to you.
Yes, ma'am. With prior permission of the bank, I have purchased the property.
Where is that prior permission?
Only oral instruction, they have purchased the property. my
Then
lord.
orally you
Kindly
request
peruse the
them.
annexure
Court
D.
cannot pass such an order. Please
Annexure
come.
D, my lord. Ink
no.
page number 50, annexure D, my lord.
The present writ petition is filed.
My lord,
The following prayer.
second respondent has filed the application.
That is
He has-
not the concern of the court.
He has ready to clear the entire loan amount.
Let them, all of them do whatever they want. We will not, these kind of writ petitions
My lord,
cannot be
kindly,
entertained.
1 minute, my lord. Kindly peruse the ink page number 50, my lord. Annexure D. They have given NOC, my lord. Bank has given NOC.
Page number?
Page number 50, my lordship.
Under which law that is given?
Whatever the loan sanctioned with account number that
This
has
is
been clear. my
certify
lord.
that so and so,
Yes, madam.
same is closed. Hence the borrower has no dues in the
Yes, madam.
captioned account as on date.
Therefore, I am requesting the bank to return the original document. They have refused to return the original documents, my lord. House property loan has been cleared, my lordship. Therefore, I am seeking.
I can understand your client is asking all this.
Yes, ma'am.
As an advocate, can these kind of prayers be entertained by the court?
And other means-
Property that is mortgaged to the bank and the amount is still outstanding, they say that the principal borrower has sought for a one-time settlement. You purchase the property.
No, other properties there, my lord. Except house property, other properties are there, my lord. My lord, again.
You cannot seek any relief from this court. Whatever you want, you go before the bank.
My lord,
Please.
currently out in 2 days time, my lord. My senior is not in station, my lord. He has to come and that has
So
argument.
unfortunate that a writ petition of this nature is pending before this court.
No, only 1
This
week.
is matter day after tomorrow.
Kindly show me interim order, my lord. Interim order also granted. Your court
There
will
is an
grant-
interim order also in this.
Yes, my lord. Means that I'm ready, I will clear the entire loan in respect of the housing
What
loan, my
is, what
lordship.
is this? How can you file writ petition?
After repayment of the loan, I have purchased the property, my lordship. I have cleared the entire loan amount, housing loan amount. Thereafter, I have purchased the property, my lord. They have given invoice on 21/7/2022, my lordship. Kindly look at the annexure F, my lord.
This is matter day after tomorrow. Interim order earlier granted is extended. And the bank is keeping quiet from 2024 without even
My lord,
filing
you
a
have
vacate petition.
We have filed our objections, my lords.
They have not put any objection, my
So
lord.
then there is a collusion between the bank and this person.
My lords, no, my lords, there's no such collusion.
Then
my lord.
in that case, why have you not sought for vacating of the stay?
My lords, the matter is it was getting listed, my lords, since there was an interim order, we have only
No,
to maintain status quo.
without you filing the vacate, that means you are not interested for that way.
My
You
lords,
want the stay to be continued.
No, my lords,
And
I'm
that
ready
they
to
have
argue
said
even
they have
today, my lords.
obligation to return the original documents also.
This is matter day after tomorrow. No further adjournments will be granted.
Much obliged.
Cell number 42, Mohammed Tahir. Yashidar.
Appearing for respondent, madam.
Limited prayer I am seeking, your lordship, to consider annexure A, your lordship, that is OTS, your lordship. One-time settlement, your lordship.
You want to consider?
My lord, this writ is not maintainable in view of section 34 of SARFACI Act. My lord, they have come towards us for negotiations. They have come towards us with OTS settlements, 231s, but they're not appropriate, my lord.
No,
We're still
lordship.
considering.
My lordship, kindly see the annexure D, your lordship.
Let her submit, yes.
My lord, we're still considering the OTS that they've come forward with, provided that it is appropriate and
This
reasonable.
is matter after vacation. Yes, 43.
Much obliged.
43,
The respondent, my lordship. We have filed the statement of objections. The issue raised by them is the areca plantation. We have produced the statement of objection along with the photographs of that one that clearly shows there's a coffee plantation. The areca plants are there in between that. So in covered by division bench judgment of our High Court, lordship. They are claiming the exemption under section 31, subsection I.
10 lakhs is deposited.
If lordship.
Within time I have deposited,
Yeah,
my lord,
that-
I am filing,
The 25 lakhs.
I am filing a rejoinder which is ready. I have
No,
filed.
25 lakhs is also deposited.
It is also deposited.
2 crores is an
I have
outstanding.
already informed them also. And
This is matter after vacation.
Date may kindly
Interim
be.
order in the month of February. Interim order earlier granted is extended till then.
cell number 44. Cell number 44, Nafisa M. For petitioner Vignesh.
I'm for the petitioner in this case, your lordships. I'm challenging the possession notice, your lordships, which is at annexure A,
On what ground?
on the ground that I'm ready to deposit certain amount, your
No
lordship.
certain amount. That's not the order. First, there should be an illegality with the order. If it is not, the second option is whatever the amount is there when you are going to pay. Only on these two conditions, the court will entertain the writ petition.
I seek 4 weeks of the time, whatever amount is being granted by this honorable court, your lordship.
Not whatever is the outstanding or whatever is the amount to regularize the account. Only those.
I am ready.
What is
to-
outstanding?
1 crore 10 lakh 96,243.
To regularize the account?
My lord, it is not possible in this matter because earlier on
Because
certification,
2
they came before
loans
this honorable
already
court.
been closed, your
This
lordships.
my lord,
When was the surface of proceedings initiated?
My lord, the account become, my lord, what had happened, my lord, initially, my lord, account become NPA in the, my lord, from day one, it is some indiscipline in the account maintaining. And my lord, subsequently, they came before this honorable court. We regularized, we given an opportunity to them. Again, account become NPA. They came and filed a writ petition before this honorable court. This honorable court relegated the matter to DRT. Now the matter pending before the DRT. At least, my lord, they would have said.
What is questioned before DRT?
My lord, demand notice and my lord, my surface.
Demand notice has been challenged.
Also you question
This is a possession notice, your lordships.
So,
I'm,
in fact, sale notice issued.
your
says-
lordships, sale notice has also been issued, your lordship. I'm willing to deposit 25 lakh rupees, your lordships, because this is my ancestral property, your lordships. Even 2 loans I had taken, which has been closed,
So please
and I have also given.
Well, the alternative remedy, there is no point in coming to this court.
Your lordship, that is on the demand, that
Fine,
is on the
that is
demand
fine.
notice, your lordship. Again, that is on the maintainability, your lordships, because it cannot be maintainable, because I've challenged the demand notice, your lordship. I'm here
Maintainable.
because they are asking me to come when the possession notice has been issued. I went prior to that, your lordship. That's the reason they are not entertaining my petition. It is still pending, your lordships. I'm challenging the possession notice which is being issued to me, your lordships.
No, tell
Also-
no, I'm not able to understand your submission. Possession note, the 13-4 notice you are questioning before this court.
Yes, your
Can't it
lordships.
be questioned before the DRT?
Yes, your lordship, but I've already challenged the demand notice, your
So
lordship.
you
That's
can't
the
question
reason.
the 13-4.
I can, your
Because
lordship.
you have questioned that, all the more reason you should go there.
Yes, your lordship, but again, I have to.
I'm sorry. Please come. The present writ petition is filed, seeking the following prayer. Then counsel appearing for the petition submits that the petition is ready to deposit 25% of the amount. Then counsel appearing for the respondent bank submits that the outstanding amount is 1 crore 9 lakhs
10 lakh
69,000.
96,243.
Huh?
1 crore 10 lakh 96,243.
Written?
10 lakh. I'm so sorry.
It is submitted that the petition has already approached the DRT when the 13-2 notice is issued and filed the essay. Petition has an effective alternative remedy. It can go before the DRT. The petitioner accepts stating that they are ready to pay 25% of the amount. There is no legal ground is raised before this court. The petitioner having already availed the remedy before the DRT, the petitioner ought not to have come before this court. Hence, the petition is disposed of with the liberty to avail the appropriate remedy before the DRT.
Cell number 45.
Much obliged.
For the petition, maybe kindly password your lordship.
No password today.
Appearing for lordship, respondent lordship.
Password may engage senior counsel for this, kindly password your lordship.
List this matter tomorrow.
No, sir.
Yes, next.
Cell number 46.
46 is adjourned.
No. My lord, morning we mentioned the matter.
Yes.
Lord, there are two petitions. The same matter, my lord.
From yesterday, my lord, it is posted to today. That there are two loan accounts. One, my lord, by the petitioner in the present case. The other one, my lord, according to them, my lord, there is a outstanding of rupees 8 lakhs. The connected petition, my lord, my friend is appearing. There is an interim order and they have deposited, my lord, I believe, my lord, that 10% is deposited. Despite the same, when there is an order of stay against the other loan account, that liability, my lord, they are trying to fasten on me, my lord. That is why, my lord, the present writ
So
petition.
we will hear both the matters.
Please.
Now, when will you pay the remaining amount? How much you have paid? By way of interim order?
86,000.
10% of my lord, 8 lakhs.
10%. Kindly see the order passed by
1
this
minute,
honorable court.
86,000. How much you have paid? 2 lakhs.
It is to my account, my lord, 2 lakh. My account, there is no due.
Both are the same petition. No difference.
Represented by different, my lord, GP holders.
Merely representing my two advocates.
No, that day the order was, you
That
said
I-
there is no outstanding in your account.
There is no outstanding in my account.
So for that account, you paid 2 lakhs.
No, to my account only I paid. Because there was an
We
interim
will,
order in
we
the
will, we
connected.
will look into it.
Please.
So when are you going to pay the remaining amount?
6 months.
Huh?
6 months.
You want 6 months for paying 8 lakh rupees? And why should we entertain?
ಅಲ್ಲ ಯಾಕೆಂದ್ರೆ ಅವ್ರಿಗೂ
Huh?
ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸ್ವಾಮಿ.
My lord, I just want
What do you say?
kindly bear with me, my lord, 1 minute. What had happened, my lord?
ಹಾ.
The first
The
petition.
petitioner is one and the same.
Same.
One advocate.
He sold the property.
No. He says he'll pay the money. The other advocate says that for the same petition, it's difficult to pay.
That's what my yesterday I submitted by way of not registered
No,
GPS.
it's very clear. If you are ready to pay the amount immediately, I'll grant another 10 days so that everything will be cleared. Or else I'll dismiss
In
both the
fact, my lord,
petitions.
subsequent petition, this honorable, they undertook before this honorable court, I'm going to pay. My lord, kindly see the order passed by this honorable.
That
In
my
which
lord,
case?
that
In
my
which
lord,
case?
without knowledge
My
of
lord,
this petition being pending.
36845.
Huh?
36845 WP, recent writ petition. Kindly see the order passed by this honorable court. My lord, it's a detailed order.
As on that day, my lord, I was not aware that this
They shall
petition.
be stay of all further proceeding pursuant to the auction sale notice dated on the condition that the petition shall pay an amount of rupees 2 lakh by so. The remaining amount shall be paid by 12/12/2025.
As on
If the
the,
petitioner fails to pay the amount, the stay granted by this court stands vacated and the bank is at liberty to take further
please,
steps.
as on that day, my lord, I was not aware, my lord, this
No,
petition is pending.
whatever you are aware is not the question. The question is what is the order impugned? What is the order that's passed by this court?
Please, that's why
That's
my lord,
recording
application is
that
filed.
submission of yours.
Application is filed, we're not seeking for modification. The 2 lakh my lord I have deposited, another 5 lakh my lord to this account my lord I am ready.
Why
I'm
should
not going
we-
back.
Why should we
I'm
do
ready.
it? Why should we do it? And why should we interfere? And what, on what ground you are before this court?
Should we kindly take my lord the DRT order?
Yes.
Not page.
Why
my lord.
did you go, why did you assign the DRT order before this court? Why did you not go
No, no,
before the DRT?
DRT my lord, the entire proceeding was closed, page 44. The outstanding.
Issue a
my lord-
writ of certiorari to quash the auction sale notice dated 4/8/2025.
Please.
Is the first writ petition.
Yes.
You appear in this or he appears in that?
Not I appear, not in 36845, I appear. Your lordship may kindly turn to page 44. There was a due, my lord, in respect of this account about 2 lakh. Page
No,
46.
Now that is clear. What they said is clear. No, they can't regularize the account in the light of the RBI guidelines.
But that, my lord, my friend will have to answer, my lord. There is an interim order, 10%, my lord, they have deposited and they have complied it. When there is a stay,
No, you will also have to face it because though you have paid the entire amount.
Please.
And the account is declared as NPA, in the light of the, he says that the
Correct,
RBI
correct.
guidelines,
But
it can't be
when-
regularized.
when there is a stay by the Honorable High Court in respect of this account, on the basis of very same my lord claim, they are trying to enforce it on me, where there is no due at all.
That is not, maybe
The interim order passed, my lord, in 7959.
Ultimately, it may boil down to that, but that is not their direct attack on that account. It is your account only, which is not regularized.
Please, my friend.
So
my
now
lord,
the only option for both of you, that is only one petitioner, either to pay the amount or I'll dismiss the writ petition. That's the
have to be
only
paid,
thing
my lord,
available.
subject to, my lord.
My lord, first and foremost, my lord, the undertaken, my lord, undertook by the my lord petitioner on the last previous occasion, my lord, sale aside in the.
Forget about
consequent
the
petition.
order. What is the outstanding amount?
Outstanding, my lord, the
8
first
lakh.
petition in respect of 8,30,000 rupees which I made, and subsequent petition, even though that account is regular, since my lord, he already alienated the property without my permission in the first petition, I cannot, my lord, regularize unless and until that account is completely closed. That is 8,30,000 rupees. Even though, my lord,
Your lordship may
once
kindly
he-
have this matter on Friday. He
He's
will have a word.
Not Friday,
interim
Thursday
order,
we'll have
interim
it.
order will not
Thursday,
continue, my
Thursday.
lord, he's not compared the interim order.
No, I have complained. My account is regular.
Complain.
I have deposited 2 lakhs.
2 days, nothing is going to happen, Mr.
Very same
Vignesh
petitioner.
Shetty. I'll pass orders on Thursday. This is matter on
Interim order
Thursday. No further adjournment. Then please don't come and mention on Thursday.
No, please.
Interim order extended.
Interim order is extended till then, and I'm going to dismiss. I'm making it very clear.
Please.
No arguments on that day. Payment or dismissal of both the writ petitions.
Please.
Yes.
Bill number 47, Satya, of preliminary hearing, 47.
My lord, this matter will have to be called tomorrow, my lord. It's the batch matter, my lord.
It's a batch matter. Is
Tomorrow
this
it
matter at 2:15 tomorrow or 2:30 tomorrow?
My lord, and let them serve copy of the writ petition, my lord. Let there be a direction. Still copies are not served.
In which one this?
In 47.
Petitioner shall serve the copy of the writ petition. I already told that all the matters bank shall be served. In
Please.
that order passed.
Please.
There shall be the counsel of the petition serve the copy of the writ petition and the counsel appearing for the bank.
Obliged.
Yes,
Bill
48.
number 48,
Appear for the respondent bank in this matter, my lord. Your lordship may kindly peruse the order dated 7/11/2025. Your lordship has directed the petitioner to file an affidavit, my lord. Till today, despite 2 adjournments, they have not filed any.
This order is on
affidavit.
7/11/2025.
Your
Yes, madam.
lordship, we have supposed to make payment of 1,82,000, your lordship. The current outstanding is 1,82,000, which is pending. And we have made all the other payments here. And your lordship had
Your
also
lordship has
asked us
directed
to
the-
go and approach the bank. We have approached the bank and we have also discussed with them, but they have not given us any.
No, that is not a direction from the court to the bank. Now, this is matter on 25/11. By the time the petitioner shall file an affidavit before this court, when the petitioners are going to pay the outstanding amount. Where is the affidavit?
We have not
But there is
filed
no other ground for this court to pass an interim order except this. Till such time, the respondent bank shall not take any coercive steps. Why did you not file the affidavit before this?
I was not instructed, your lordship. I'll receive instructions from my senior and I will.
You don't have to, neither your senior, you have to give instructions to you, or this court has to give. There is an order which is not complied with. I'll vacate this interim order. List this matter tomorrow. By the time if the affidavit is not filed, the writ petition shall be dismissed on that ground. Is 49?
bill number 49, B. Rajaya,
Yes.
My lordship, this MC case pending in before the family court since 1.5 years. The
Mm.
respondent intentionally dragging the case, my lordship.
Principal Judge, Family Court, Bangalore, to dispose of MC 3650 of 2024. Why?
My lordship, the respondent is keep on changing our counsels, my lordship.
So?
Since it is in pending, my lordship, since 1.5 year.
2024 matter, why should it be disposed of expeditiously? Why should there be a direction from this court? When the matters of 2016 are pending before the family court?
But
Please
they are
come.
not appearing before this. court.
The petitioner, the present petition is filed, seeking the following prayer. The MC that the petitioner seeks expeditious disposal of MC 3650 of 2024 within 6 months. There are several pending matters before the family courts at Bangalore. In fact, on the administrative side, this court has already directed the family courts to dispose of the matters till 2019 by 2019 by April 6th. This MC is of the year 2024, and this court do not find any reasons to pass any order. Dismissed.
Cell number 50. Gauri Shankar M.
My lords, I'm for the petitioner.
Yes.
Husband in this case. My lord, the brief facts of the case is, my lords, the trial court, family court was pleased to have granted 10,000 rupees as the interim maintenance. My lords, I am agreed by that. I'm 39-year-old. I'm the husband, and I have a mother who is a widowed mother, aged mother, and also two dependents who are my sisters. They are also, one of them is a widow. My lord, in fact, if my lords could peruse through Annexure A, my lords, that's the
What is the salary of the petitioner?
63,000, my lords.
Why can't he pay 10,000 to the wife?
But my lords, if I may appraise my lords, if my lords might go to paragraph number 12, 13, 14, the trial court has appreciated the evidence of the wife, my lords, wherein she is getting more than 35,000, my lords, but the trial court has granted 10,000. So the suppression of facts has happened, my lords. Therefore, I would be put to grave inconvenience as a husband to maintain the wife, my lords. Annexure A, my lords, paragraph number 12, 13, 14, all that appreciated by the
Then counsel for the petitioner submits that the salary of the petitioner is 60,000 and not, and the wife's salary is 35,000. Court had granted maintenance of an amount of rupees 10,000 per month when she is having, and he has to support the parents.
The mother, my lords.
The petitioner
Mother
has
and
to support
the
the
sister, widowed sister.
Support the mother and the sister. And the court, without considering all these aspects, and particularly the aspect that she's earning 35,000, has granted 10,000. Considering the submission of the land counsel for the petitioner, they shall be stay of all further proceedings. The petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. This is if the memo is not filed by January 12th, the stay granted by this court stands vacated. Yes.
Cell number 51.
I'm so grateful. Grateful.
Siddhappa. Petitioner V. Suresh.
For respondent, my
It
lords,
is matter, 10
on
10
9
lakh.
12, my lords, court has
It is
granted
submitted
in
with the land counsel for the petitioner that by 10/12/2025, the petitions will pay an amount of rupees 10 and the remaining amount by 23/10/12/25, and in
10
this
lakhs.
regard, they'll file an undertaking.
10 lakhs blood are already paid on 10/12.
Undertaking affidavit.
Undertaking affidavit ready is there today.
They have not
Blood,
paid
one,
on
one,
10/12,
one submission. One submission. The instead of 23/12, my client is working in a project in Chennai Railway, but he is getting a bill in the first week of January. Kindly have it on kindly the amount extend the time till 10/1. We will clear the another 22 lakhs. Then regularize the account.
After
Another
that,
15 days.
After that, another 2 months.
No, my lord. Further extension, my lord. I'm undertaking to further extension, my lord.
directed to pay on 10/12, my lords. They have paid on 11th, my lords.
10/12.
One day after.
One day after.
One day after, Allah.
I'm producing the
File that
statement, my
affidavit.
lords.
File that affidavit will consider list on Friday. Interim order granted earlier is extended till then. What is there in this?
My lord, in the
Interim order.
No,
Like,
list this matter on Friday.
in this matter, my lord, instead of 23/12, my lord, 10/1 I can put. My lord.
That's what file your affidavit will see.
Great.
Case 52.
Vinayak Kamat.
In this case, I have filed a
Interim order is not there. He says it is not there.
Unnamed relief.
After paying 22 lakhs, court has directed to.
Redeliver the bill.
Redeliver.
We will see on Friday. Yes,
Hello,
please.
my lord, interim order is there. They are going to action on
Give
that.
that, give that.
Interim order was there.
Why even on that also you, both of you are disputing? Where is interim order?
Kindly, my lord.
That's what it's there. Bank shall not go
The
ahead. with
bank
the
shall not go ahead with.
Auction, my lord.
interim order earlier granted is extended till then. List on
Great,
Friday.
great.
Yes. Which case is this? 3-5? Yes.
Lordships appearing for
In this case,
petitioner.
for the respondent, Canara Bank, I filed a wakalat today. Your Worship.
In this particular case, we have engaged a senior advocate, Sri D.R. Ravishankar sir. So if it matter is called at 2:30, it would
It's
be.
not possible.
Otherwise,
Afternoon
we are,
I will
no,
be-
I'm ready
I
otherwise.
submit your
Matter
lordship.
on
On the
Thursday.
similar relief, he has also filed a WP
Thursday.
6780.
No, I am ready. Your- Otherwise, I am,
It's already 1:30. On
Alas.
Thursday is 53.
Your lordship.
maybe tomorrow,
Submission.
Lordships.
Similar, on the similar
We will
prayer.
see on Thursday. I don't-
Because today is
No,
the
no, one
auction
submission.
sale.
He has also
Lordships.
filed one writ petition, 6780 of 2025.
It's along with that.
Yes,
Yes, 53.
6780.
Maybe tomorrow, Lordships.
Give it right
Yes,
on the paper.
Lordships, maybe list it tomorrow.
Day after. Yes.
Bill number 53.
For the petitioner, my
For
lords.
respondent.
My lords, petitioner, my lords, with great difficulty, he has adjusted 2 lakhs, my lords, and is getting it, my lords. Is on the way, my lords. So kindly have it tomorrow. We will give the DD, my lords, for 2 lakhs.
Obliged.
Bill number 54.
Not for a petition in this case, please, my lord. In this matter, the family court has not considered my application for interim maintenance. It is
From
been
when?
filed from March 2020, March this year, my lord.
March?
This year, March, my lord.
20?
March of 2025.
This year, March.
This year, March.
The presented petition is filed.
Annexure C, page number 25,
1 minute.
please.
The writ petition is filed. Seeking a direction to the Family Court Bangalore to consider and dispose of I number 3 that's filed in OS number 144 of 2025 for interim maintenance within 15 days from today. When the land council submits that, when an interim application is filed scheme maintenance, the court ought to have considered the same at the earliest. This writ the OS is filed in the IA is filed on 27/3/2025. Why the court has not considered, the court ought to have considered this application within 1 month. But it appears that the same is pending from the month of March. Hence, there shall be a direction to the court to dispose of the matter by, within matter by end of January.
Please. Obliged.
Expeditiously, yes.
Please.
55.
Appear for the petitioner, my lord. I haven't seen my children for 1.5 years. 3 days was given. He didn't allow the mother to see the
I
child.
appear on
Then
caveat in this
afterwards-
matter. Yes.
My lord, then I understand your lordship is sitting in a bench. I don't want to put pressure. They were served on
If it takes time, I'll have it tomorrow.
tomorrow. my lord.
It's tomorrow.
Grateful, your lordship.
They should
Yes.
maybe be directed to file the memo along with the written submissions, a written reply,
Whatever you want
short,
to,
brief
yes,
reply. No?
56.
Bill number 56.
Great.
Yeah. Ladyship, I have been paying the interim maintenance of 20,000 cash and 45,000 for the residence to the respondent wife. And after that, I lost my employment on 1st of October of this year. So I had moved IA number 14 in the family court to take cognizance of that and mutatis mutandis reduce the proportion of the interim maintenance. This order IA 14 rejected my application. There is an infirmity here, as I've stated in my point number 6, that on para 18, page number 18, the trial court has noted that petitioner cannot be allowed to escape the responsibility of maintaining his wife and children. But the children have always been in my custody for the last 4-5 years.
Permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo. Once a memo is filed, is the matter is 57.
Ladyship, I have requested for interim relief. So if the
Yes.
57, I may be permitted to.
Sir, one TP Muttanna, Learned Counsel for the
What is
bank.
the name?
TP Muttanna, my lord, Union Bank of
So and so is directed to serve, is directed to take notice on behalf of so and so. The petition, the list is matter on Thursday. Yes, 58.
Serial number 58.
The petitioner is challenging the possession notice which has been attached to the property of the petitioner, wherein the borrower, I am not the borrower nor the guarantor. Earlier, same possession notice already been challenged before the same, it is pending before the court, my lord. And in annexure, maybe 106 page, my number, my lord. Earlier, writ petition was filed challenging the very same by one of the defendant.
Why it is listed before this court? How can it be? What is the relief you are seeking? No bank is a party to this. These all actions under section so and so. Who has initiated the action under 13.2?
My lord.
Who has initiated the action under 13.2?
The attachment is by the respondent number 2, my lord.
Who is respondent number 2?
The bank, my lord. Tata Capital Housing Finance. With the very same possession notice which is pending before the court of 12, my lord, as on today, wherein they have admitted they have withdrawn the earlier possession notice and issued the very same notice with some changes, my lord, attached to the very property of the petitioners, where I am not the borrower nor the guarantee. And further, my lord, the respondent number 1, who is the borrower of the said loan, the title is still in dispute. And
Where
before
is the
the
connected matter pending?
my lord.
Where is the connected matter pending?
Yes, my lord.
Where is it
In
pending?
court of 12, today it is listed, my lord.
It is submitted that there is a connected matter pending before the pending before court number 12.
Yes, my lord.
After obtaining the necessary instruction, district is directed to this matter along with that. Necessary orders from the Honorable Chief Justice.
59 Jagan Mohan.
Lord, this petition filed for the relief of mandamus to direct the family court to dispose the matter expeditiously because it is filed in 16/11/2022, my lord. There is no proceedings taking place, my lord, because once it is referred to mediation, it without
Why the court has no other matters except your matter?
Lord, they have filed IA 4 and 5. IA filed by petitioner for the interim maintenance.
You are seeking a
Respondent
direction.
also filed. They are not passing the orders.
Seeking a direction to dispose of the MC.
Yes, my lord.
Not the IA.
Lord, because the trial court strangely recorded, kindly see the page number 55 and 56. No evidence taken place, not commenced, madam. But no, my lord, because it record strangely recorded, both parties have already completed their evidence and posted for arguments for main matter.
Like the court will take its own course. Why should we give a direction?
Lord, because respondent.
Supreme Court has specifically directed the high courts not to pass that kind of an orders, fixing the board of the trial court unless and until it
even
warrants.
then it is not passing the orders on IA number 4 and 5.
That's not the relief
Finally,
you are
it posted
seeking.
for arguments on merits because
Is it the relief you sought? Please look at the prayer.
Lord,
If you have sought at that relief, we will
on
pass
ma-
an order.
on all sought direction to dispose the matter.
IA,
At least within 1 year, maybe.
if it is IA, you please make the amendment to the prayer. I will pass orders, not on the main MC. Yes, adjourn. 60.
Serial number 60. Tanima Baker.
No representation. It's already 140. List this matter tomorrow. 61.
Serial number 61.
Yeah, for the petitioner in this matter, my lord. The subject matter is that the petitioners are not the borrower or it is a sibling of one of the borrower. During the pendency of the partition suit, an interim order was granted by the trial court, my lord. During that, the mortgage has been created.
Tomorrow, 62.
62.
Lord, I appear for petition. The challenge, my lord, is to an order passed under section 14. In fact, my lord, the sale had taken place. My submission would be, my lord, that once the sale has taken place, my lord, the financial institution cannot, my lord, could have invoked section 14. It's covered, my lord, by the judgment, my lord, of the Calcutta High Court. And upon that, my lord,
Tomorrow.
my lord, what has happened, my lord, they are at my doorsteps to take possession. I had moved the matter on Friday, my lord, they are at my doorsteps. Even now, my lord, they are at my doorstep.
As against, my lord, the order of, my lord, sale, he had approached the DRT has confirmed the sale. As against that, my lord, an appeal was filed before the DRT, it was dismissed. And that, my lord, then he filed a petition which has not come before the court for the last 12 months. It is at the
That,
stage
my
of
lord, is
office
with regard to
objections.
DRAT order, my lord, what I have challenged is only with regard to the quantum that I had to deposit. They are aware, my lord, that the matter is pending, my lord, before this honorable court. They should not have precipitated the action. They invoke, my lord, section 14 on behalf of, my lord, the purchaser.
Unless and until an interim order is there
No.
from this court, why should they stop?
Oh, my lord, I can understand, but section 14, my lord, can, my lord, the financial institution invoke is the position. Once, my lord, the sale has taken place, my lord, let us admit, my lord, that the sale has taken place.
Then first,
Oh, they had not taken possession.
first you sell the property, then you take position under
No,
14.
no, earlier, no, an order was passed by under section 14, both by the purchaser and as by the institution, finance institution. Against that, an appeal, writ petition was filed before this court. This court said that only the financial institution can invoke section 14. Therefore, the financial institution has now filed a section 14 application and it has been allowed. And as against the sale, it has been confirmed.
No.
Only, what he says that, since he is in possession, therefore his possession should be protected. That cannot be, I have an order, wherein he has not even stated.
Yes, question the
about
sale
all
notice, sale proceedings, everything.
Please, I have question.
Yes, tomorrow.
Please.
Yes, next.
Serial number for admission.
Till then, my lord, let them not precipitate. My lord, what has happened is they are virtually at my doorstep.
No. Yes.
Ashok Kumar B.
I appear for appellant, insurance appeal challenging liability, my lord. Insurance appeal, insurance company appeal, my challenging liability. The tractor of insured was purchased from agriculture purpose. They have pitted borewell lifting mission, my lord, without permission from RTO.
What matter has come? Same.
Serial number 33, it's connected matter.
Same order as in serial number?
33.
Yes.
64.
64, my lord, is the claimant appeal, my lord. R2 is the ICICI insurance company.
Respondent 65. Notice.
Serial number 66.
Petitioner queries for the respondent. My lord, he directed them to file a memo of calculation in proof of compliance of the orders. That has not been filed or served. And my lord, tomorrow.
67. Serial number 67.
My lord, that memo. 66 you give me.
Yes, 60.
Memo.
67. Criminal hearing because. E. Rajaya, 67.
Listed after vacation. If interim order is there, extend.
Serial number 68.
For a direction to take the child to therapy tomorrow, my lord.
68 tomorrow.
Your Honor, there's no urgency in the matter. It can be taken up after vacations, Your Honor. Already the child is undergoing therapy, Your Honor. Already the child is undergoing therapy. He's also having his visitation.
His urgency you can't tell.
Certainly, Your Honor.
Yes.
Serial number 69. B.B. Ravishankar. Yes, Mahendra.
It can be taken up after vacation, as after vacation.
Serial number
70.
Interim order be extended then.
In 69, interim order to be extended. 70.
70.
My lords, it's infructuous, my lords. Sale has not taken place. It is rendered
It
infructuous.
is submitted that the writ petition is well questioning the sale notice and the sale has not taken place. And hence the petition has become infructuous. Yes, 71.
Respondent, can be taken up tomorrow, my lord. There is an interim order, my lord.
Yes, 71 tomorrow.
Maybe after
72.
vacation, my lord.
They have the urgency. 72.
72, lords, it is only for mandamus, lords. Lords, we have settled, lords, the entire amount under the OTS, lords. Lord, they have to release, lords, the original documents, lords.
Who is
Lords,
who
it
is the
is
council
served-
appears
it
for
is-
Indian Bank?
Lords, it is served, lords, nobody appears, lords.
Huh? No, it's served. Bank panel councils are there. We'll direct them to appear.
Lords,
Which is the bank?
lords, Ibrahim will appear.
You appear for? Who appears for Indian Bank?
Indian Bank of India.
Lords, Ashok Naik.
Ashok?
Ashok Naik.
A petition is directed to serve the copy of the writ petition on Mr. Ashok Nag for Indian Bank.
Lords,
We shall get instructions, list this matter after
lords,
vacation.
lords, tomorrow, lords, I have some urgency, lords.
No, without even.
Lord, I
finding
will
out
serve
the
copy,
facts.
lords, today itself, lords. Day after tomorrow, lords.
You have to understand the difficulty of the courts also all the time. This is matter day after tomorrow.
Update.
Yes, 73.
Serial number 73.
Your Ladyship, I am appearing on behalf of the petitioner on the matter. I am audible to the Honorable Court.
Sir, your voice is not clear to the court, sir.
Ladyship, am I audible to the Honorable Court?
Yes,
Am I audible to the Honorable Court, my lords?
4.
My lords, am I audible to the honorable court, your lordship, ladyship?
Tomorrow we'll see.
Ladyship, I'm in 74 for the petitioner. My lords, I come from Delhi, my lords. It is impossible for me to come tomorrow, your ladyship. May hear me out for a moment, my lords. My lords, in 73, the petitioner is
You can
always.
appear tomorrow also online. Yes, 74.
Please, I'll be grateful.
74.
74 day after tomorrow.
Cell number 75.
All these matters day after tomorrow.
My lord, so 76 tomorrow, my lords. It's a fresh matter.
Serial number
It may be
79.
directed to be listed preliminary hearing. It was
One
there.
minute, 1 minute. 75 who appears?
75 Soumya.
This day after tomorrow, 76.
I appear for petitioner. This is a fresh matter which is from yesterday to today. They've taken instructions.
Yes,
my lord.
tomorrow
In
is
preliminary
77.
hearing, my request.
70.
For the petition.
Huh? Yes, day after tomorrow, 78.
My lord, tomorrow's my lord. There is an interim stay they have obtained in survey. I'm for the respondent, my lord.
Yes, 79.
79. Similar 5 petitions have been dismissed. Again, they have filed a fresh petition.
My lord, kindly have it tomorrow, my lord.
Yes, 80.
80. Cell number 80.
80 after vacation. All these matters which are adjourned, interim orders are extended. 81.
81 tomorrow, my lord. There is an interim,
Yes.
not to precipitate. There is.
No, all banks want all interim orders to be vacated this side of the vacation only.
Lord,
Yes.
82, my lord.
We'll have it after vacation.
No, my lords, very much urgency is there.
Lord,
Yes.
one small
Next.
submission in 82, my lord. It's a part heard matter, my lord. Could it be tomorrow? My lord? Or
Five
day after? My
petitions
lord?
Or it's not possible because again tomorrow from
Then could it be
afternoon
day
that
after?
batch is
Please,
there.
please.
That's why.
Then could it be day after
Day
tomorrow?
after tomorrow,
My lord, may I
82.
make one more request, my lord? Could it be at 2:30, my lord? Because, my lord,
82, 230.
please, oblige.
Yes. Any signatures?
Lords, apologize, my lords, in serial number 40, IU may be extended.
Wherever interim order is there, it will be extended, whether you ask or you don't ask.
Madam?
78 also tomorrow. One ನಿಮಿಷ sir.